Uh, the program today aptly reflects at least four different aspects of the Miranda decision, four different things that it's appropriate that we acknowledge on its 50th anniversary. One, of course, is the namesake of the case, Ernesto Miranda, and you'll hear a bit about him later today from Captain Cooley, who was involved in his arrest. You also have in the materials a really interesting article by Barry Silverman talking about how he came to know Miranda. Ironically, less than 10 years after the case that his arrest inspired, Miranda would ignominiously die in a barroom fight here in Phoenix. A second aspect of the Miranda case that's important is, of course, the various lawyers and judges who were involved in the decision, and you're going to hear from Paul Ulrich about that. It involves several of the most important and colorful figures in our legal history, people like John P. Frank, John Flynn, legendary criminal attorney, Bob Corcoran, who as a young ACLU attorney would help get the case to Lewis and Roca, where Paul and others would work on it. Interestingly, this is an aspect of, interestingly at least to me, this is an aspect of Miranda in which there's a bit of irony. When I look out my office at the Supreme Court, I look across Wesley Boland Plaza. There is only one judge among the many memorials and statues out on that plaza, and that's Ernest McFarland. McFarland, of course, a legendary Arizona political figure. He served as a senator for 2 terms. After he was defeated in 1952 by Barry Goldwater, he came back to Arizona, where he served 2 terms as governor. And then, in his words, to round out his public career, he decided to run for the office of justice on the Arizona Supreme Court. And he succeeded, and it was McFarland who wrote the Arizona Supreme Court opinion that ultimately would lead to the Supreme Court's decision, the United States Supreme Court overruling the Arizona Supreme Court, which had held that Miranda's confession under the totality of the circumstances was voluntary. The irony is this: John P. Frank in the 50s had been sort of unofficial legal counsel for Ernest McFarland, Democratic governor. So the Miranda decision, one aspect of it, it reflects a lawyer securing the reversal of his former client's opinion in the Arizona Supreme Court. The third aspect of Miranda that you'll hear about, and you'll hear about this from Bob McWhorter, is, of course, the decision's doctrinal background and its ongoing significance for our legal system. Miranda reflected, in a way, the apogee of the Warren Court's efforts to make our criminal justice system more fair. Earl Warren thought that the privilege against self-incrimination reflects that our government must respect the dignity and integrity of its citizens. And he also, in the opinion, observed that a custodial interrogation is inherently coercive. And he thought, and wrote in his 5-4 decision, that in order for a statement that's obtained during a custodial interrogation to be admissible, it would have to be preceded by those 4 unforgettable warnings: the statements to a suspect that they have a right to remain silent, that any statements that they make can and will be used against them, that they have a right to consult with and have a lawyer present during an interrogation, and that if they're unable to afford an attorney, one will be appointed for them. Warren observed in his opinion that a prosecutor under our system is not paid to get convictions, but instead to protect the rights of the people in the community, and to see that if there is a violation of the law, that there is a prosecution and trial under fair judicial standards. Now, the Miranda decision, of course, will be very controversial. It was a backdrop during the 1968 election for President Nixon's argument that the Supreme Court had been soft on crime, and that if he were elected, he would appoint strict constructionists who would uphold the law. One consequence of President Nixon's victory was the 1971 appointment of William H. Rehnquist, another Arizonan, of course, who would have an important connection to the Miranda case. Just a few years after Rehnquist joined the court, he would write an opinion in a case called Michigan versus Tucker. And in that case, then Justice Rehnquist observed that the Miranda rules were actually prophylactic standards. They were not themselves rights protected by the Constitution. And that prompted some uncertainty about the future of the Miranda rules under a newly constituted Supreme Court, because of course Justice Rehnquist was also joined by other appointments by President Nixon, Justice Powell, Justice Blackmun, and Chief Justice Berger. In fact, Justice Rehnquist in 1975 would help write an annual skit that the law clerks performed at the Supreme Court. He loved the holiday party, he loved music, he loved skits. And one line in the skit was, save Miranda, save Miranda, save Miranda from the Nixon Four. Now, that really wasn't as pretentious as it may have seemed, and this is my last point about some of the ironies in the Miranda case. 25 years after that skit was performed, then Chief Justice Rehnquist would write the court's opinion in Dickinson versus United States, the case where the court, in a 7-2 vote, affirmed that the Miranda standards were in fact constitutionally grounded and were binding on Congress and the states. And as Chief Justice Rehnquist then observed, not only did stare decisis argue in favor of upholding the Miranda standards, but by then they had become part of our national culture. So you'll hear much more about the Miranda decision this morning. You have a great panel of speakers. And again, I appreciate the opportunity to be able to come and start off this program today.
It's my privilege to introduce our next speaker. My personal connection here is when I came back home to Arizona, oh gosh, it's been more than 10 years, to practice law. I knew Paul Ulrich as probably the most prominent, most respected appellate advocate working in the state of Arizona. And I was lucky because he had a law firm that had extra space, and he rented me and a couple of other sole practitioners room in his law firm, so I got to see him every day. He was my landlord. But also I got to work with him because he chaired for years the production of the Arizona Appellate Handbook for the State Bar. I did not know at the time that I wish I did, but I did not know at the time that in the earlier years, he not only worked on the brief to the U.S. Supreme Court on behalf of Ernesto Miranda, but then later, when the original conviction was reversed, he personally represented Ernesto Miranda. So, very, very fine lawyer, brilliant lawyer, and some personal knowledge about this case. Everybody, please join me in welcoming Paul Ulrich.
Thank you and good morning. I am not Chief Justice Scott Bales, so put that down. Well, it's good to be here and I appreciate being included. My take on Miranda and related things is really quite different from Bob McWhorter's, and I will get to that. My involvement in it, as Steve says, is that well, from my point of view, is that this was all totally accidental. This is not something that I set out to do. I had graduated from Stanford Law School in 1964, where my tax professor was Joe Sneed, for whom Scott clerked later, and who became a good friend of Judge Ben Dunaway, who I clerked for the next year. I had that clerkship, and I had an offer to join Lewis and Roca in September 1965, and so I did that after the clerkship was over. Miranda cert petition was filed in July of '65. It was granted in November of '65. And so that just kind of I had no idea the case was in the office. Lewis and Roca at that time was a firm of about 30 lawyers, primarily involved in civil litigation, except for the criminal department, which was primarily John Flynn, who was by all accounts, the leading criminal defense lawyer in Arizona at that time. So the cert petition is granted, a brief needs to be filed. I and Bob Jensen, who's still practicing in Phoenix, helped John Frank write the brief. John Flynn argued the case. This was a pro bono ACLU referral. The firm handled it for free all the way through. And when the case was reversed and it was remanded for a new trial, I then helped John Flynn with the retrial in the kidnap rape case, which was the one that went to the U.S. Supreme Court. Miranda was convicted again. There was an appeal. I wrote the brief on that appeal. Conviction was affirmed. I wrote the cert petition to the U.S. Supreme Court, which was denied. So that's and then my career was as a civil appellate lawyer. I did not practice criminal defense law. I have no dog in this fight at all. I was away from this subject for over 40 years. And then as I retired and thought about it and read and reviewed what had been written over the years about Miranda, I realized there was some misinformation, some errors, some unintentional, some perhaps not, and that needed to get straightened out. With the 50th anniversary coming up, I think there needs to be a view of what this is all about, and it's not just the Miranda decision, it's what the Supreme Court did with it over the years, which is easy to romanticize. So I am not a romantic in particular. I want to give you the specific nuts and bolts about what happened and what occurred and what happened later if we get into that panel discussion later. So you may have a different understanding of what Miranda was about than you now think you do. Okay, so let's start. I'll leave the investigation and arrest and all of that to Officer Cooley. In the first trial, Lewis and Roca was not involved. Miranda was represented by a court-appointed lawyer named Alvin Moore. He was a 73-year-old lawyer who handled court appointments. He was not a skilled criminal defense lawyer, but he was appointed counsel. Miranda was arrested in March of '63. He was tried in June of '63. Gideon versus Wainwright was decided in March of '63, which held that indigent criminal defendants have the right to appointed counsel at trial. That's all, at trial. And so Miranda had appointed counsel. It was a one-day jury trial before Judge Yale McFade. And the record that was made, which had to be the basis for later appeals, was very simple, really, in relation to the retrial, which I will get to later. But what happened at the first trial was that Officer Cooley testified concerning the confessions. He acknowledged that he had not advised Miranda concerning his right to counsel. There was no requirement then that he do that, so that was not his fault. The victim identified Miranda as her attacker without any explanation as to how or why she could do that. She identified him in the courtroom, and Alvin Moore did not present any defense case. What he did do, though, was to say he objected to the confession on the basis that the Supreme Court says that a man has the right to counsel at the time of interrogation. That was the objection, right to counsel at the time of interrogation. And Judge McFate says, no, there's no such right. Objection overruled, confession admitted, Miranda is convicted. All right, June of '63. Alvin Moore takes the appeal to the Arizona Supreme Court, to Justice McFarland, who wrote the decision. And in between '63 and April of '65, when the Arizona Supreme Court decided the case, the U.S. Supreme Court had decided Escobedo versus Illinois. And that case held that in a situation where the suspect was being interrogated, he asked for a lawyer, the investigation had focused on him, his lawyer was at the police station banging on the door saying, I want to see my client. The Supreme Court says, under those circumstances, we hold there is a right to counsel at that time. This is 1964. So there then began to develop a body of case law with, what does that mean? How far does that go? Do you have to have a request for counsel? Because the U.S. Supreme Court had said in another case in '62, Carnley versus Cochran, that where there is a right to counsel, it does not depend upon request. You do not have to have a request. If you have a right to counsel, you have a right to counsel. And again, the Supreme Court holding in Escobedo was on these facts. We hold there is a right to counsel. So apparently, Alvin Moore includes Escobedo in his brief to the Arizona Supreme Court, and the Arizona Supreme Court says, Escobedo is distinguishable. Miranda did not ask for counsel. There is no issue as to voluntariness of confession. Moore never raised that issue. There was no attempt to have a voluntariness hearing. Voluntariness and the Fifth Amendment were not in the case at that time. The Arizona Supreme Court says simply Escobedo is distinguishable. Miranda did not ask for a lawyer. There's no record as to voluntariness. Conviction affirmed. There was a companion robbery case, which was a different set of facts, different crime, same set of interrogation and confession and trial. The objection that was made there by Moore was the confession in the robbery case is inadmissible because it's not voluntary, because Miranda is entitled to a lawyer. But he didn't pursue the subject of voluntariness. The way to do that under Arizona procedure was to have a voluntariness hearing and prove under the facts that the confession was involuntary. Nothing like that happened. And so the Arizona Supreme Court could easily affirm that conviction, saying that there's just no record of anything relating to voluntariness. So this is now April of '65. Bob Corcoran's participation begins here. He later became a Superior Court judge, Court of Appeals judge, justice on the Arizona Supreme Court for about 10 years. He also screened cases for the ACLU to refer cases that he thought were worthwhile to ACLU cooperating counsel, which included Lewis and Roca, which took 2 cases a year. So Corcoran initially tried to refer the case to Rex Lee, who was then a young lawyer who had clerked for Justice White. He was at Jennings, Strauss, and Salmon. He later he got the call to become the founding dean at BYU Law School and became president of BYU and Solicitor General of the United States, but that was all in the future. At this point, he was a 1-year lawyer, And he declined because Supreme Court clerks can't take cases in the U.S. Supreme Court for 2 years after they finish their clerkship. And the reports are mixed on what he thought about the case. But anyway, he declined. Corcoran had spoken with Moore, and Moore really didn't want to continue. He was not able or willing or up to it. He was, I think, beyond his depth in pursuing these cases any further. So Corcoran then thought of John Flynn at Lewis and Roca. And the other background here is that Corcoran had worked at Lewis and Roca when he first came to Arizona from 1959 until 1962. John Flynn had come into Lewis and Roca in 1961, so they were acquainted, and Corcoran had a very good friend, James Moeller, who stayed with Lewis and Roca until 1970 and later also became a justice on the Arizona Supreme Court. And Corcoran asked his friend Moeller, how do I get this case to John Flynn? And Moeller said, well, John is a fact man, and you've got to get him pissed off, and you've got to get him to read the transcripts. That's how you get Flynn to get involved. Flynn really was a legend in his own time. I don't know if any of you know him or have heard of him. He was a remarkable trial lawyer. He was not an appellate lawyer, he was a trial lawyer. He had a charismatic personality, he focused on the facts, he was very intense. He would stand up in a courtroom and not say anything and just walk around, and people would follow that and hang on his every word. It was just I've never quite seen anyone else like that in my career. But he could do that. And so he agreed to take the case. Of course, the case was going to the U.S. Supreme Court, and that meant that John Frank, who was then the firm's senior appellate lawyer, would have to be involved. Now, John Frank had quite a different background. And, just to go back to Flynn for a minute, he had grown up in Tortilla Flat, Arizona. He had been a combat Marine in World War II. He'd gone through University of Arizona undergraduate and law school in 3 years with a C average, with a wife and children and 3 jobs, and got into dirty shirt, criminal law, defense practice for a while. That was what he was like. On the other hand, John Frank had grown up in Wisconsin, law degree from Wisconsin, advanced law degree from Yale, worked in the Justice Department in World War II, clerked for Justice Hugo Black in 1942, worked briefly in the Arnold, Fortas, and Porter law firm in Washington, D.C. in 1946. That's Abe Fortas, who was later on the Supreme Court. He written books about Justice Black, about the Supreme Court, about other justices on the court, and he was regarded as a national appellate constitutional scholar on, in relation to the Supreme Court. So, but it is clear, and this has been a point of contention over the years, the case did not come in to John Frank. John Frank did not argue the appeal. John Frank wrote the brief. But the earlier step was a cert petition. A cert petition tells the Supreme Court, U.S. Supreme Court, what the case is about, why they should grant review, what the issues are, why it's important. And that was, keeping in mind now this is an ACLU referral with a 1% statistical chance of being granted, the job of doing the cert petition was given to Bob Jensen, who, and this is before my time, but I've heard Bob tell this story. He had practiced for 4 years in Minnesota, had come to Arizona. He joined Lewis and Roca in May of 1965, a month before the Miranda case came into John Flynn. And Bob said at a meeting that's been recorded that I have the DVD of, that he was called into John Flynn's office. John Frank was there, and they told him, we have this case, please write the cert petition. Well, his background was in civil litigation. He had no experience with cert petitions, and so he went off and learned about how to do a cert petition and learned the record and saw the issues that were in the Arizona Supreme Court decision, and he wrote the cert petition, which was filed essentially as he wrote it, he says, signed by John Frank and John Flynn. And the argument that was made in the cert petition, which is what all the Supreme Court knows about the case, is that there ought to be a right to counsel at interrogation. Escobedo should be read broadly, and by this time there's a conflict in cases all over the country, and that conflict needs to be resolved. And that's the only argument that could be made, given the record. So what happened then in the Supreme Court, which I certainly was not aware of at the time, I've read about it since, is that instead of processing these cert petitions routinely every week, as the court generally does, they held all of the confession cases until November of '65. And at that point, there were over 150 of these cases pending. And they granted cert in 4 of them. And then granted in a 5th one, Johnson versus New Jersey, which dealt with retroactivity. So there are 4 cases out of 151 that are granted. That means 147 equally meritorious cases are denied, so that takes care of those. But the issue is the right to counsel at interrogation and Escobedo. All right, so at that point, that's where I start to come in then to help with the merits brief, having had a background of all of 1 year as a Ninth Circuit law clerk. And at that point, there was discussion between John Frank and John Flynn as to what approach should be taken with the brief. Now, keeping in mind now that the cert petition was purely right to counsel, and there was no Fifth Amendment issue, no voluntariness issue, no warnings issue at all in the case. Just wasn't. And so the way it worked out is that the brief argued the same issue presented as the cert petition, the right to counsel at interrogation without request, without having to request counsel. And the argument was a black and white right to counsel argument, that the right to counsel is a critical stage in criminal defense. If you don't have counsel at that stage, having counsel at trial doesn't mean anything because there are confessions. And therefore, if there is a right to counsel at a critical stage, as had developed in other cases after Gideon versus Wainwright, certainly interrogation is such a critical stage because rights can be lost at that point. And in any event, that's sort of what Escobedo had held. The only difference was that Miranda had not requested a lawyer. And so Escobedo needed to be extended to situations where the suspect did not request a lawyer. That was the argument. And the brief acknowledged, it may be that as the result of this, there's not going to be as many confessions, there's not going to be as many convictions, and that's just too bad because people are entitled to have counsel at that stage. So that's the argument. And the other cases, the other related cases, as I understand it, made similar arguments. The whole issue was right to counsel, need to request counsel, how far does this go? So I think they gave Bob McWhorter the wrong amendment to report on here today. It was Sixth Amendment all the way. But a funny thing happened during the oral argument when John Flynn argued. Normally, when you argue an appeal of any kind, particularly the U.S. Supreme Court, you focus on what's argued in the brief. You refine what's in the brief. You anticipate the justice's questions about that issue. You know, you have no way of knowing what they think about the case going into the argument, but the whole idea is to sell the court on the issues raised in the merits brief, you know, with the cert petition before. But John Flynn didn't do that. And nobody knew. I know I didn't know, and it come back, I didn't go. It was free. The case was free. I couldn't go. But I found out, you know, how did the argument go, John? Well, it went fine. You know, nobody really knew what he said. I didn't know until 1993 when there was a book and tapes of U.S. Supreme Court oral arguments called May It Please the Court, which had excerpts of the actual oral arguments made in Miranda and quite a number of other famous U.S. Supreme Court cases. So you know, keeping in mind that you have 30 minutes at most for oral argument, what Flynn did was to just start off about the facts of the case at some length and how unfair it was to interrogate Miranda. And then he said, you know, and Miranda has a Fifth Amendment right against self-incrimination, and if he has a Fifth Amendment right to request counsel. Now, that was not in the case at all. That was totally new. And it goes back, I think, to the disagreement that John Frank and John Flynn had, and it's perhaps reflected in the fact that the U.S. Supreme Court's opinion rejects the Sixth Amendment argument. They say, in the opinion, it is suggested that there should be a right to have a station house lawyer. There is no such right to have a station house lawyer. Well, that was the whole point of the argument that was made to them. But what happened next in the argument is that there was a conversation between Justice Stewart and John Flynn, and Justice Stewart says, well, what would a lawyer advise a suspect in a custodial situation? And Flynn, this is what Flynn said, and I'll just quote it, and I don't know if he had prepared this or he did it spontaneously or what, but what would the lawyer advise the client in a custodial situation? Well, that he had the right not to incriminate himself, that he had a right not to make any statement, that he had the right to be free from further questioning by the police department, that he had the right at an ultimate time to be represented adequately by counsel in court, that if he was too indigent, too poor to employ counsel, the state would furnish him counsel. Now that sounds a lot like the eventual Miranda warnings in the decision. But then Flynn says, the only person that can adequately advise Ernest Miranda is a lawyer. So at that point, he is still staying with the position that a lawyer has to be involved at the interrogation stage. Well, okay, so Gary Nelson argues for the state. Gary Nelson was an assistant attorney general then. He later became attorney general. He was a judge on the Court of Appeals. He was a Arizona Supreme Court staff attorney. He says, well, it is arguable that Miranda is entitled to a warning before he made any statement, but if the extreme position were adopted that a suspect must have access to counsel during interrogation or intelligently waive counsel, a serious problem in the enforcement of our criminal law will occur. When counsel is introduced at interrogation, interrogation ceases. Okay, so there is a tension then, which is really the core issue here. And this issue continues until today, and I think it's maybe one reason why you're all here, because Miranda is not just a historical artifact. The issues are here today. And the issue is, let me just state it generally, that where you have a suspect, a criminal suspect, and the police think or believe or have a feeling in their gut that that suspect committed the crime, but there's no independent evidence, no fingerprints, no eyewitness identification, nothing that you can tie to that suspect, how can you convict that suspect of that crime, keeping in mind that there are such things in our legal system like the presumption of innocence and the right to counsel and the privilege against self-incrimination, freedom from unreasonable searches and seizures, all those things that inconvenience the police process. How can you resolve? Because if you say, well, we're going to honor the right to counsel, and you don't get a confession, then many times you can't convict that suspect because there's no other evidence or not much. And so that possibly guilty person goes free, and from a police point of view, he may have committed crimes in the past that he hasn't been caught for. He may be a bad person who will commit other crimes in the future that you can't prevent because he's out on the street, and so how do you deal with that? And that is the tension. And so what was argued in the Miranda brief was there's our Sixth Amendment right to counsel. The right to counsel there, if you don't get a confession, well, that's just the way the system works, because these protections are there for the individual. So when you think about then what Miranda held, it is that, and Justice Bales referred to this inherently, or maybe it was Bob, referred to inherently coercive atmosphere in interrogation. And Inbow and Reed were going strong with police interrogation techniques, which involves deceptive, psychologically coercive interrogations. In that situation, the police can give the warnings and then get the waivers from people who really don't understand what's happening most of the time, who are in this custodial interrogation situation, get the waivers and then interrogate and then get the confessions. And so you have essentially the same thing, and literally the warnings are simply lip service. It's like the difference between June and the June bug, Warnings about the right to counsel, mumbled or given in passing, are not the same thing as having counsel present. Now, there was an uproar when Miranda was decided. It was, the Warren Court was soft on crime, the suspects have the trump cards, it's a terrible thing, and that led to the political uproar, which in turn led to the election of Richard Nixon, which in turn led to Chief Justice Berger and conservative justices for forever. And it was all caused or instigated by Miranda as a focal point, and it was promoted, I think, as a misunderstanding of what Miranda really was. And there are justices have made statements down through the years showing that they understand that. But one, when the Dickerson case was decided, which is the case that's been referred to that affirmed Miranda as a constitutional principle, U.S. Attorney General Janet Reno stated in a press release, this was in 2000, today's decision, which is Dickerson, recognizes Miranda rights has been good for law enforcement. Miranda set out clear standards for police officers, helped get confessions admitted into evidence, and ensured the credibility of confessions in the eyes of jurors. It will continue to provide a public sense of fairness in our criminal justice system. All right, what that is, then, is the illusion that constitutional rights have been respected, giving credibility and respectability to these confessions. and this is from the U.S. Attorney General. This is not the head of the local public defender office. This is the U.S. Attorney General. So in any event, and I hope that there will be time when we get into the panel discussion to talk about later history, but my mission now in the next 15 minutes or so is to talk about Miranda's retrial. I don't know how many of you were reading newspapers or watching TV in 1966, but there really was an uproar, a national uproar, and Miranda became the poster child for criminals and crime, particularly racial crime, which was threatening to a lot of people at that time. And, there was a recent movie called Bridge of Spies, which involved Rudolph Abel in the late 50s. I don't know if any of you saw that, but in his time, Rudolph Abel symbolized Russia in the Cold War, and he was the most terrible person who ever was. And the movie is excellent. It's about efforts to defend him. Well, Miranda was like that. In fact, when the case went back for retrial, Maricopa County Superior Court judges were subject to political reelection. This is before the merit selection process kicked in. And so all of the Maricopa County judges recused themselves. Nobody wants to take this on and be subject to defeat in reelection because you might accidentally let Miranda go. Can't have that. So Judge Lawrence Wren was from Flagstaff, Superior Court Judge in Flagstaff, was designated to handle the trial because he was not a part of the judicial politics of Maricopa County. Now, from our perspective in defending Miranda, we got a ticket to a new trial, and what that involved was no confession, fruit of the poisonous tree, so you can't use any evidence resulting from the confession, and all of the discussion in the case about what it might mean in the future and so on wasn't really applicable to our immediate situation. But we did have fruit of the poisonous tree, which is a well-established constitutional principle that says that any evidence that results from illegally obtained evidence, directly or indirectly, is also inadmissible. So what the second trial turned into was a 9-day jury trial, not a 1-day jury trial. And it was hearings, about 8 days of it was hearings with a jury sequestered in the Adams Hotel. And the purpose of the hearings was to try every single piece of evidence that the state offered. There was no pretrial discovery or disclosure or anything at that time. State would offer, exhibit whatever, this piece of evidence. So the question was, where did it come from? How did the police become aware of that piece of evidence? And there would be a hearing, and police officers would testify as to how they came to find out about this evidence. And it turned out uniformly that it all derived from the confession, suppressed. So if you go on like that and you suppress all the evidence, there's nothing to submit to the jury. And the judge has to acquit Miranda. Well, that's unthinkable, and the judge here, in a hallway conversation, talking with John Flynn, God damn it, John, I'm suppressing all this evidence. I'm going to have to dismiss this, and I just can't do that. I can't do that. There was, however, a saving grace for the state, who was Twyla Hoffman. Twyla was Miranda's common-law wife. She did not testify in the first trial. When Miranda, they had a child, a 2-year-old child, by their relationship. While Miranda was in prison, Twyla had a relationship with someone else and had another child. And Miranda thought that he would get out of prison, and he thought that Twyla was unfit to have custody of their child because she'd had a child with this other man. So she went to Bob Corbin, who was then the county attorney, told the story of this. And her story was that she had come to see Miranda in the jail after 2 or 3 days, where, keeping in mind now that Miranda had confessed, he had no advice about remaining silent or right to counsel. He was sitting there feeling sorry for himself, presumably, and she asked him, "Did you confess to the police?" And he said yes, and then he told her again, essentially, what he had told the police about committing the crime. And so that's her testimony. You may ask, well, how did we get to this point procedurally? Anyway, by stipulation, Miranda had been permitted to testify, not to the jury, but to the court, about the circumstances of his confessions and the circumstances of his being in jail and the circumstances of the confession to Twyla Hoffman to establish the facts. Now, none of these facts had been known before. I mean, not in the record. They were not in the first trial. So, and one of those, for example, was the victim. How was it that the victim identified Miranda? Miranda had been interrogated for a couple of hours, and he had denied being involved in these crimes. The police brought down the 2 victims, the kidnap rape victim and the robbery victim, and put Miranda in a lineup and said, "Can you identify the person who attacked you or robbed you?" And they both said, and we're concerned now with the kidnap rape victim, well, gee, I don't know, maybe number 1, who's Miranda, maybe he sort of looks like the guy, but I can't identify him. And but maybe if I hear his voice, I might be able to identify him. Okay, so I believe this is Officer Cooley who was involved at this point. So Cooley goes back into the interrogation room with Miranda, and Miranda says, in effect, "Well, how did I do?" And Cooley says, "Well, Ernie, you didn't do very well. She identified you." Now, that was not true. She did not identify him. She needed to hear his voice. So at that point, in response to that, Miranda confesses. That's how the confessions were obtained, as the result of that lie. All right? But lies are okay. U.S. Supreme Court case law says lies are okay for law enforcement to get confessions. It's not okay for defendants to lie, but it's okay for police to lie, because these people are guilty anyway, you know. All right. So, so Miranda then gives written and oral confessions. They bring the woman into the room, and the voice sample is, Cooley asked Miranda, "Ernie, is that the girl?" And he says, "That's the girl." And she then says, "That's the man." So the identification is based on the voice sample, which is based on the confession, which is illegally obtained. And so on that basis, the victim identification went out. She could not identify him because that was fruit of the poisonous tree. Now, the part where this all went astray was that on cross-examination in one of these out-of-jury hearings, the prosecution asked Miranda whether he had done the things that he had told the police he had done. Objection. That's outside the scope of this hearing. That's not, no, the U.S. Supreme Court has held those confessions are illegal. It doesn't make any difference if they're voluntary or not. Overruled. Yes, yeah, I did it. Okay, I did the things that I confessed to the police. And at that point, then, Judge Wren allows the Twyla Hoffman confession to come into evidence. The jury convicts quickly, and that's what goes up on appeal to the Arizona Supreme Court. Now, at this point, Judge Malloy, who was Chief Judge of Division II of the Court of Appeals at that time, was sitting by designation on the Supreme Court. He wrote the opinion. And the argument that was made, that asking about, did you do the things that you confessed to, that's improper. And is the confession to Twyla fruit of the poisonous tree? So what the court says is that the confession was not fruit of the poisonous tree. The confession was sufficiently attenuated from the first because the right to initial warnings did not exist until sometime subsequent to the conduct. No reference to any evidence supporting attenuation. That proposition is illogical on its face. Whether there's awareness of rights to begin with, whether those rights existed, has nothing to do with attenuation at all. And then the court says there's a sufficient break in the stream of events leading to the second confession without stating any specific facts that created that break. And there were no facts. There were no facts supporting a break in the chain of circumstances. That had to be proved beyond a reasonable doubt. There was a recent U.S. Supreme Court case that said that if there's going to be a break in the chain of circumstances, it has to be proven beyond a reasonable doubt. And there was no evidence at all of attenuation or break in the chain of circumstances. But that's what they said. Now, none of this, on reflection, was the Arizona judiciary's finest hour. On the other hand, the defendant was Ernest Miranda. So we filed a cert petition, this is it was May of '69, or February '69. And by the time that gets filed and considered in the fall of '69, the Supreme Court's membership has changed. Earl Warren retired. Richard Nixon appointed Warren Burger. Abe Fortas had to resign from the Supreme Court because of ethical problems with the Wolfson Foundation. Thurgood Marshall had argued a part of the Miranda group of cases when he was Solicitor General, so he wasn't available. And the times had changed and there was no interest, and that's how it ended. So, I don't, and I will get to, I guess, I guess I should, if I got a few, I'll just mention the robbery case. Johnson versus New Jersey said that Miranda is not retroactive to trials occurring before the Miranda decision. That meant that it didn't apply to Miranda's robbery case because his trial was before and that's kind of outrageous when you think about it. But that was the rule, wasn't retroactive at all. So John Flynn was able to persuade a federal district judge that somehow or other the Miranda decision should apply to Miranda in his robbery case. And then, but that was delayed, and Flynn left the firm and took Miranda with him and retried the robbery case and tried it under a synonym because Miranda was so well known, and he was convicted anyway, and that conviction was affirmed by the Arizona Supreme Court, and I don't know much about that. I wasn't involved in that. So that part was unsuccessful. So when you consider it, who Miranda was or what he did or what he was like or that he was killed in a knife fight in a bar and he had a poor education and a poor childhood and a criminal record, none of that, or what the police did, none of that really makes much difference here. What really comes down to is how did the Supreme Court deal with that conflict in values between respecting the presumption of innocence, the right to remain silent, the right to counsel in particular, as opposed to creating a situation where the police could continue to get confessions without having lawyers involved. And that's what the Supreme Court did. And then what I want to talk about, just if I have a chance in the next half hour in the panel, is, well, how did that play out? No, you can't, again, you cannot consider Miranda as a one-shot thing. You have to consider it in relation to all of the restrictions and limitations and twists and turns that the Supreme Court applied over the next 50 years, including, Michigan versus Tucker, and Quarles versus New York, and Oregon versus Elstad, which was decided when Justice Bales was clerking for Sandra O'Connor, and others, and that's another whole story. That's the rest of the story to be continued in the next half hour. Thank you.
Tim Moore is in the back of the room. Tim Moore, raise your hand. Tim Moore was for many years the liaison between the Phoenix Police Department. I knew him as Detective Moore. Liaison between the Phoenix Police Department and the Justice Courts, and I worked with him for years in that capacity. Tim is also a writer, and one of the books that he's put out with a co-author is Miranda's Nation. And Tim has done the research from the point of view of the police department. This book reads like a Dragnet episode, just the facts, but it'll go, he's interviewed Captain Cooley, he's interviewed all of the officers that were alive at the time, or still alive, that were involved in it at the time. He's read all the police reports. He lays out all the facts for you if you want to know more about the facts. I think he has a few of these books with him, and he'd be happy to sell them to you. And he also serves, by the way, on the board of the Phoenix Police Museum, which we're going to urge people to go see on their way out across the street. So, now I'll come over here. Because this is the time for the panel discussion. What happened to Mr. McWhirter? Must be. Okay. All right. Well, we'll let him come. Yeah. We're going to start the panel discussion. I've got a question I want to ask, but if you're ready to go, Paul.
Well, ask your question.
All right.
This is like the TV debates. You know, maybe I'll answer it and maybe I won't.
Well, I'll start with a confession. I have a very good friend. My wife and I are going to go visit him and his wife in Germany in a few months. But 20 years ago, my good friend, his sister was the victim of a brutal attack. He went with the police to the police station, and not in Phoenix, a different city. But he was there in the police station for about 15 hours, and the police came out with his confession to the crime. And he would have probably spent a long time in prison, except that his sister recovered, and when the police detective came in to tell him that they'd identified their assailant, she laughed at the police defendant and said, that brother of mine weighs at least 100 pounds more than my assailant. At which point, only then did the police start doing crime scene investigation, which led to the conviction of the actual perpetrator of the crime. But having seen that, and also, having read Dostoevsky's Crime and Punishment, my question is, are confessions a bad piece of evidence? Just inherently a bad piece of evidence?
Well, that really depends. I think can you hear me?
No, push the microphone closer to you.
It's on. Okay. Can you hear me now? Yeah. Well, as I think I said earlier, the criminal justice system with which you're all familiar depends upon confessions. And if you had to try every single case without confessions, that's just impossible. There's not enough money to build all the buildings, to house all the judges, to handle all the trials that would be required. So the system depends on voluntary confessions. And Miranda goes out of its way to say that voluntary confessions are always with us, and we're not doing anything about that in this decision. The problem, well, Miranda is limited in its time frame and its scope. It is limited to the initial interrogation, and the police decide to interrogate someone. They have to give the warnings and get the waivers to proceed with the interrogation, wherever that leads. And Miranda is only concerned with the circumstances of the warnings and waivers, not what happens later. All the talk in the decision about the burden of showing that this was voluntarily done and so on focuses on that moment, not what happens later. And the problem is, and this was a problem in 1966 with Inbow and Reed, were the leading writers and counselors to police on the subject of interrogations. They promoted a whole system, it's now called the Reed technique, which is deceptive, psychologically coercive interrogation designed to get confessions from people who the police believe are guilty. Never mind, that they may not. And then the problem is then that there may be there are different kinds of confessions. There are true confessions which may be the result of that relentless interrogation and psychological coercion, which doesn't rise to the level of involuntary. But there are true confessions and there are false confessions. And the one that you've described where the police walk in with a confession, that's a whole different matter. That's even worse. But there's a recognizable number. Many people have been convicted based on false confessions. There's a notorious case, which is referred to in my article, Central Park 5, where 5 black Hispanic teenagers in New York City were interrogated separately because the police believed they were involved in the rape and assault on a white woman jogger in Central Park. They just kept after those kids until they confessed. They got lawyers. They argued that the confessions were involuntary. They hadn't properly been warned of their rights, moved to suppress the confessions. The judge denied the motion to suppress because that would gut the case in a situation where there'd be public uproar if these kids were let off. Argued to a jury that those confessions were coerced. Jury convicted them all in 2 separate trials. There was no appeal, but later, when one of the kids in prison met the guy who actually committed the assault and rape on that woman, and his DNA matched the DNA on the woman. The police and prosecutors knew that none of the teenagers' DNA was on the woman, and they went ahead anyway. And after spending between 8 and 13 years in prison, they all sued the city of New York and the police and the prosecutors, and after 10 years of litigation, ended up with a $40 million settlement, which worked out to $1 million per kid per year. And that whole thing is outrageous. There's a case in Arizona, the Jonathan Duty case, where Duty as a teenager was relentlessly interrogated for 15 hours and confessed. And finally, the Ninth Circuit went through the Arizona court system. They said it's okay. The Ninth Circuit finally reversed and said you just can't interrogate that way. And then eventually Duty was convicted again based on testimony of another defendant who the police had promised they wouldn't seek the death penalty if he would say that Duty did it. So, the whole problem here, but one more step in this is that there are ongoing battles day by day in courts around the country between prosecutors and defense-oriented psychologists who are able to speak to this post-warning psychological deceptive interrogation, hopefully, and where there are videotapes that show what really happened throughout that process. And many judges will not allow that testimony. And the Reed Group has an online website where they keep score nationally. There are all these experts, and there are these cases, and in these cases, these judges have failed to allow that testimony, and and every time that's a win for the prosecution. But I guess, Steve, this is a long answer to your question, but deceptive interrogation is alive and well, and Miranda did not address that point. And that is a point that is being fought daily. Maybe, I don't know if it's come up in your courts or not, but it certainly could, and particularly in more major crimes. And that is an issue that needs to be addressed.
Mr. McWhirter wants to speak, but also remember this is a panel discussion, and Mr. Adornetto is standing over here with a mic for anybody who has questions. Just raise your hand.
Well, I think the problem is almost all confessions are coerced. Almost all. Now, with the exception of the guy who shoots somebody and says, oh, call the cops because I want to tell them right now. Okay, fine. But that's very rare. So almost all confessions are coerced. So the problem isn't whether there's, well, it is coercive behavior that gets the confession. The problem is what is truthful and what's not. And that's where the problem comes, and that's why what Miranda tries to center on is some kind of a procedural mechanism or protection to avoid a coerced confession that is untrue. But that gets to be very difficult, because what the police can say is, well, yeah, but aren't you just avoiding a coerced confession that could be true? So there's the problem. So how do you get at the problem? It was mentioned the Duty case. Well, the precursor to the Duty case were those poor kids in Tucson who admitted after hours and hours of police interrogation to committing the crime. Duty was the second round. And Gary Stewart has written a very good book, Innocent Until Interrogated, which kind of goes through that entire thing. They got these, 4 or 5 guys down in Tucson to admit to killing 9 Buddhist monks up here after this whole process of coerced interrogation. Now, that could have stopped at any time if any one of them would have said, hey, can I have my lawyer? I want my lawyer. What the premise of Miranda, and this has been mentioned quite a lot, is kind of a look at, hey, what's the social justice aspects going here? What are the racial aspects going on in the criminal justice system? Rich people have their lawyers on retainer because they can say, hey, that lawyer that did my stock option, I'm sure he knows a criminal lawyer, and they get him right away. The problem, of course, because this is also the time Gideon is coming in, is what's the fairness for poor people who don't have access to that? And Miranda, I think, leaves open a crucial problem, which is after you're arraigned, you get a right to a lawyer. Well, what about all that other time before? That's where the problem comes. So if you really want to, I think what it has to center on is how do we know these coerced confessions are reliable, and what are the indicators of that, taking into account the methodology that gets used in the Reed method of interrogation, et cetera. I don't know about you, but as a criminal law practitioner, I've seen Miranda be used as a tool of interrogation. And the way it goes like this is, hey, Steve, I know I really want to hear your side of this story, but don't talk to me now. Don't tell me now. I got to read you these rights, okay? But I want to hear your story, but I can't hear it now, because I'm all chummy with you. Yeah. And we're buddies, and I'm going to tell you these rights. And after I tell you those rights, so can I get you a Coke or something like that? And I will get you whatever. Boom, and after... Some of the best police officers I ever said this, like, how do you coerce a confession? How do you get a confession? Just get the guy talking.
Well, and many people will talk and confess, and their confessions are voluntary because they're trying to talk their way out of the situation.
Yeah.
Or minimize their involvement. Well, I was there, but I really didn't do anything. It was this other guy, my friend, he's the one who pulled the trigger, and I was just out in the car. No, well, that doesn't really help. But people think that if they say that, then that will excuse them, and in the Central Park 5 case, the kids were told, well, if you sign these confessions, we'll let you go home. And that was and they were really beaten down after 16, 24 hours of continuous interrogation.
Okay. Also, everybody remember Captain Cooley's here, and you can ask him questions, but I think I saw in the audience, Judge Jane, didn't you have a question? Oh, all right.
You know, I mean, we need the police to do this work. Nobody wants to work in a system of impunity. Okay, I worked for a year in El Salvador administering a USAID package. Utter impunity. I spent most of my time working with police and prosecutors, developing systems. So it has to recognize the valuable work the police officers do for us all, but how do we create some kind of mechanism to assure the reliability of the confession? And I think Miranda has to be read as the first attempt of the court to do that, but not the last.
Well, but that leads into the general question of how did the Supreme Court apply Miranda down through the years? And what was the general feeling about it, you know, which that's in my article from pages 24 to 30 or so, if you get it. But what is clear to me, and I'll just give you some of the high spots, is that, you know, as I said during my initial presentation, the result of the Miranda decision was that Richard Nixon was elected president in 1968. And the result of that was several conservative justices appointed, which created a conservative majority. And the first thing, one of the first things they did was to say that Miranda doesn't apply where the defendant has the audacity to testify in his own defense. If he testifies in his own defense, this unwarned confession can be used to impeach him because Justice Berger says the shield provided by Miranda cannot be perverted into a license to use perjury by way of a defense free from the risk of confrontation with prior inconsistent utterances. So they cut back there, they cut back on retroactivity, and the major thing that they did was to say that the Miranda warnings are not really constitutional principles. They are simply prophylactic rules, so that it is possible to say that even if a confession is not admissible, if the defendant says, I hid the gun in the storage locker, or the car is off in a garage someplace, or my friend knows something about this, all of that evidence can be used. And by the way, I confessed prior to this, and here I am confessing again, but all of the protection of fruit of the poisonous tree and cat out of the bag was taken away from the Miranda warnings because, and Chief Justice Rehnquist and Sandra O'Connor were the worst offenders here because they could say that the Miranda warnings were not a constitutional principle, they were prophylactic rules, which is a second-class protection. The remedy for Miranda violations is only to preclude the confessions, but not to preclude all of the evidence that resulted. So if that had been the law when we retried Miranda, we could not have done what we did, which was to have all of that evidence suppressed. Now, the Dickerson situation then becomes more complex because going along with the idea that the Miranda warnings are just prophylactic rules, Congress passed a statute which redefined voluntariness of confessions as being solely constitutional voluntariness, coercion. And at that point, Chief Justice Rehnquist said, Congress, you can't do that because the Miranda warnings are constitutional principles. Well, you know, what about the fact that these prior cases, you know, some of which you've written, say that it's only prophylactic rules? Well, never mind, but that's just a normal evolution of constitutional law. And then they continue to hold, there's a case called United States versus Patain, which involved a confession leading to a gun. And in light of Dickerson, Patain says the sole remedy for Miranda violations is to prevent the confession from being used, and it's okay to use the gun, which is the direct result of the confession. So, and somehow, without explaining it, they say that the Miranda warnings are different from other constitutional principles, even though the only base, and this has been pointed out repeatedly in Supreme Court decisions, the only basis for the U.S. Supreme Court to have reviewed the Arizona Supreme Court decision in the first place was because there were constitutional principles involved, and the Miranda decision itself says we are here deciding constitutional issues and principles. So you start out with the fact that it had to be a constitutional issue. Miranda was decided on that basis as a matter of convenience. Later, Rehnquist and O'Connor and that majority said it's only a prophylactic rule. Everything following it is okay. And even after they say in Dickerson that it's a constitutional principle, it's still not the same as truly coerced confessions or illegal search and seizure or something like that. So it's, if you were uncharitable, you could say that's hypercritical. But the result is to permit convictions to occur even if the confessions are illegally obtained. And I don't see how, as a matter of principled justice, you can do that. But they have, and that's the law. That's the way it is.
Okay, we do have a question.
Everyone in the room here probably has a smartphone that can take out and take a video. Do you think we've reached the point now where the police should be required to videotape as a constitutional matter, a due process issue, that the police should be required to videotape an interview like that? Do you think that would help? Do you think it would help enough and might actually help vindicate the police in some respect because we could see them doing their job the right way?
I will tell you that Chief Justice Bales, before he left, said to me that he suggested that's a possibility of where we'll wind up.
Well, it's more than just the cell phone. It's in the interrogation room to have videotaped interrogations that go on for hours so that there is a record that an expert can look at and say, well, here's the point where this deception occurred. Here's the point where there was psychological coercion. Here's where the defendant changed, but otherwise you just have he said, she said between the defective and the defendant. The most recent example of which around here is Deborah Milkey, and what it came down to there was non-disclosure, but Detective Saldati had no video record, no witness, no written confession, no nothing except his word that she had confessed. She denies she confessed. No disclosure that he had been repeatedly found guilty of lying and depriving other suspects of their constitutional rights, and that's why the Court of Appeals eventually dismissed that case. They found it just totally outrageous, and it would be helpful from that standpoint if there were videotapes to confirm what goes on from initial arrest through confession. Yeah.
Well, just briefly, the answer to your question is absolutely yes. And by the way, the ones who are going to push that, a lot of good, the vast majority of confessions, the police do a really good job. And the ones who push that are the cost-benefit people in police departments, because forget what happens with a confession. Somebody's going to be suing somebody. Somebody gets a long sentence, they get bored and start filing lawsuits, and they just say, look at this video. You got everything you deserved. It's end of case. So I think that's going to have a good effect all through the system. And we are in the world of cell phones. So, yeah.
Yes, there's a Gary Restaino in the back. Stand up and shout, Gary. You can be heard.
Watch out.
Thanks. I would say at the outset, this is a somewhat narrowly constrained panel in terms of the viewpoints you're representing. So thanks for being balanced. I really do mean that. I think that's a nice way to do it. But let me ask a question on the confessions. We know that they are getting more and more taped audio, video, et cetera. What's the predicate threshold before you think an expert gets to challenge the confession, whether from a Daubert standpoint or just a practicality standpoint? It can't be that every time a defendant wants to take back their words, they can get that expert in there.
Go ahead.
What exactly, I mean, when does like an indigent defendant get funds for an expert, or when can they have it? I think there's a key issue of admissibility, and you've got to establish that kind of threshold that the judge is a gatekeeper before the jury can hear the expert. If that, yeah.
That's my question, Bob, is what do you think, what kinds of threshold factors before that expert's really going to get to opine to the jury about just the observations? Because it's not going to be in every case.
No, I think there's got to be some basic threshold, and also jurors cut through stuff like that really quickly. I mean, I generally limit my use of experts as a criminal defense attorney. I think if you don't have other compelling things, the expert's not going to win your case for you. Nobody's going to say, oh, wow, that shrink said this, and therefore whoopee-doo. That just doesn't work. People tend to believe the police officers when they have a reasonable position. So I think that would be the control, which is the judge is a gatekeeper. And the other thing is you got to find a reputable expert that's willing to say it, too. Look, I think this was problematic here. I will tell you that when I've had confessions reviewed, many times my experts come back, and I know you guys never see them because that's the last you'll hear of them. This was fine, no problem here. Okay, well, we're not going to take that path for the defense. So,
Well, but aren't those heard as motions or evidentiary hearings to the judges? They don't go directly to the juries.
you
It's on a
can,
motion to suppress. The judge
Right.
decides whether the confession is admissible or not.
look, this brings up kind of an interesting issue about Miranda, which is one of the problems of Miranda, and criminal defense attorneys kind of forget this too. There's still the issue of voluntariness. The law before Miranda was voluntariness. Was it a voluntary knowing waiver of rights, et cetera? Miranda came in and gave a separate standard for suppression or evaluation of a confession, which can be won or lost on its own merits. In addition, the giving of Miranda rights is an indicator of voluntariness, but there can be other indicators of lack of voluntariness or voluntariness, and that still exists. And many defense attorneys kind of miss that. In other words, Miranda rights were given, done. No, there's also, were there other things overbearing this person's will, his psychological condition? So that law still exists as an issue in Miranda and implicates, I think, what's going on here in the discussion here as well.
Charlie, are we ready? Okay. So, then I'm going to turn the panel over to you, Charlie, because I think you want to do a couple of introductions and correct something I said earlier.
Actually, we're going to take a 10-minute recess, and at 11 o'clock, Captain Cooley is going to take us home.
It was 11:30 at night, March 2nd, 1963. A young woman, 18 years old, by the name of Patricia Weir, got off work at the Paramount Theater, 2 blocks from here, still there. Not called the Paramount anymore. It's had several names in its history. So when she gets off work, she starts to walk to the bus terminal. Excuse me. And there's a young man that works there also, and he walks with her. They board the bus at the bus terminal at about midnight and proceed to the northeast side of the city. Patricia gets off at her stop, 7th Street and Marlette. And when she gets off, she's now going to walk to where she lives. She lives with her married sister and her sister's husband. They live at 1014 East Citrus Way. That's about 4 blocks from Marlette and 7th Street, where she got off the bus. As she starts to walk, a car pulls out from behind a strip mall on the northeast corner. She says she had to jump back to keep from being struck by this car. The car goes east on Marlette. It travels down there about a block or so and then pulls to the side of the street and turns the lights out. It was in front of us, some apartment buildings. She didn't think anything about that, and so she walks along. Very dark place. I don't recall there being any street lights at that time, and I'm not sure there is even today. There's no curb, no sidewalk. There's some residential houses, and as she walks along, because of some trees in front of these houses, accenting the darkness, so it's pretty spooky. And as she walks the street and she goes to pass the car that's parked by the road, a man comes out from somewhere in the dark, grabs her, places his hand over her mouth, puts her arm up behind her, holds it, and says, "Don't scream and you won't be hurt." She's terrified, obviously. She struggles a little, but he takes her to the back of the car, opens the back door. It's a four-door sedan, pushes it into the car, onto the back seat where he just happened to have a couple pieces of rope with him. He pulls the ropes out and he binds her wrists and her ankles. He then closes the door, gets in the car, and drives somewhere northeast of there out into a remote area, somewhat believed to be in a desert situation. There, when he gets there, he gets out of the car. He goes over, opens the door, and in the meantime, she has managed to get the ropes off of her wrist. He unties her ankles, and he says to her, "Get undressed." And she says, "Please." She's already been pleading with him, but "Please don't do this. I'm a virgin. Please don't do this." Now it's pretty obvious what his intentions are. That to no avail. She won't get undressed, so he undressed her. And in doing so, he tore the strap on her slip. When he has her nude, he then pulls off his trousers and his shorts and forces himself between her legs and tries to complete sexual act with her, rape. She squirms and she's resisting. So he stops and he waits a few moments. Didn't get out of the car, just kind of waited there. And they tried again. And at one point, and I think it was earlier, he had put something sharp against her neck. She assumed it to be a knife. And he warned her not to scream, and to cooperate. That was in the car. Whether he did that back when he first picked her up or whether he does it now, the stories by the victim changes slightly as she tells the story over and over to different officers. He then completes the act of rape. He reaches a climax, and then he gets out of the car, relieves himself. He gets back in and tries once again. As he does, this third attempt, he's perhaps not able to perform, or maybe he lost his interest, or I don't know what happened. But it didn't go on beyond the one initial penetration. When he's finished, he says to her, get dressed and I will take you home. She gets dressed. After she's dressed, he says something to her that's very unusual, strange. He says, "Whether you tell your mother about this or not is up to you, but pray for me." And so at that point, he then says, "Do you have any money?" She says, "I have $3 or $4. Give me your money. So she opened her purse, gave him what she had, $3, $4. He then drove, first off, he told her to lay down on the seat. He put her jacket over her head and said, "Don't look out." He then drove back the direction they came from. And at one point, she looks out and she sees the sign, a street sign, 16th Street and Rose Lane. Then they go on from there, and he lets her out of the car. It's either on 12th Street and Rose Lane or 12th Street and Bethany Home Road. She tells different locations slightly. Depends on who she's talking to. She runs home. She's crying. She tells her older sister, Sue Williamson, what happened. Sue calls the police. Patrol Officer Page arrives shortly, gets the story. He then has to call his supervisor because this kind of a crime is a serious crime, and the Detective Bureau or on-duty detectives would handle the initial investigation. Back in that day, they only had one car, one two-man car, worked from 11 to 7. Kyle Gordeau and Don Davis were the detectives that night, veterans officers. They get a hold of him because the supervisor obviously called him. They get a hold of Paige, and they tell Paige, tell the victim not to bathe or clean up. Have her take her underclothing and put in a brown grocery shopping bag, like they used to use before they had plastic, and says, "We will meet you at Good Samaritan Emergency." Page then does as he's told. They get in the car, the sister goes with them, and they take her to the hospital. At the hospital, the detectives meet. They go over her story also, once again. And they listen to Officer Page's account. And they had 2 doctors, and they gave her a vaginal examination. They told the detectives they collected a great deal of sperm. And they also told the detective, "We will protect that evidence, make a report, and send it to you. And if necessary, you can call us to testify if you need it. We will keep that evidence here at the hospital." The officers finished the interview. They talked to her, and after they talked to her, there was a nurse there, and they said to the nurse, "Watch her when she gets dressed after the examination. See if there is any evidence that she may have been tied up or knife placed on her skin or anything revealing that this was a forceful situation." The nurse says she saw nothing that indicates that. The doctors saw nothing. The doctor said to the detectives, "She claims to be a virgin, but we don't think she is." Not that that makes any difference in a rape case. She could be a prostitute, it wouldn't matter. But that's what the doctor said. They go back to the department and they write the reports. Procedure at that time with a major case is you have to finish a report before you can leave at the end of your shift. So the detectives go back, they write the report, and they turn it in. The reports are handwritten in that day, and then they're typed by a clerk typist. After they're typed, they are routed to the correct detail and to the Record Bureau. That, of course, is in the early morning hours of the 3rd of March. The next morning, the reports are there, and The detective sergeant for the detail is Seymour Nealis. And Seymour he would have read this report, and he would have recognized that there was a potential here to be a lot of publicity with this report, particularly if the press expands on this. A young lady, a teenager, kidnapped off the street at knife point, tied up, taken out into the desert and raped and robbed, sensationalize the report, and of course, it would be newsworthy. He would have wanted to have the best detective that he could find in that detail, the guy with the most experience, the guy with the most training, the guy that knew these kinds of cases, ins and outs, very successful detective. Well, obviously, he looked around, he didn't see that guy. So he hands a report to Detective Cooley, that's me. How much experience do I have? I've just told you, very little. Now, I read the report, and I take care of some other detail, other reports that I have to do paperwork on or make phone calls or whatever, so I don't get out until later on that day. So I go to the address on their address at 1014 Citrus Way. When I go there, I ask the sister who answered the door if I could speak to Patricia. She says she's not here, she's working. Won't be home till late. But she says, I want you to come in, I want to tell you about Patricia. She says, I think she's a virgin, even though the doctor said that she wasn't. But she's very naive. She's not real sharp. She's not retarded. She described her as being bashful, rarely would ever talk to Sue's husband, her brother-in-law. And when she did, she wouldn't look him in the face, and she mostly just answered the question. Very shy person. She had a problem. She had failed a number of classes at Phoenix Union High School, so she dropped out. You might say she wasn't the brightest bulb in the chandelier, but she was an innocent young lady. Now, whether she was a virgin or not is, like I said earlier, is immaterial. The sister didn't think so. Well, she thought rather she was a virgin. She didn't agree with the doctors. From there, I went to the theater. Patricia's working that day in the ticket booth. I identify myself and asked to speak with her. She said, I can't right now, there's nobody to relieve me. So we made arrangements for the next day. She could come to the department and view mugshots, rogues gallery, you might say. There you would see robbery suspects, child molesters, and other sex crime people that had a record. The next day, she comes to the department. She doesn't find any picture that would identify this guy. I review the material I had with her and had her go over the story once again with me. And I got a better description of the suspect. He was Hispanic, possibly Italian. He had no accent whatsoever that it would indicate a person of Hispanic or any other background. So after I got that, she described the interior of the car as very shabby. It had ropes across the back of the front seat. She had never seen that before, and so she thought it was maybe homemade or something added later. Vertical striped upholstery on the back seat, brown. Car was described as being light green. So after we had that and went over those reports, and we had another detective that had interviewed her during the day on it happened, because we had a suspect that they wanted to show her in a lineup. He tried to avoid the police, and they brought him in, and because I don't know why, because his report didn't describe it, she was, once again, that day, the 3rd, she was interviewed. That detective found discrepancies in her story as well, changes in her story. Well, if you know policemen, you know we don't believe much of anything anybody tells us. That's the nature of our work. We're very skeptical. We're kind of like Reagan when he talked to Gorbachev. You know, we'll trust, but we'll verify. So that's what we do. So there was a little bit of doubt in our minds. So we asked if she'd take a polygraph. She said yes. I arranged for the polygraph. It was on Thursday that week. Sergeant Earl Moore was a polygraph operator. And after the polygraph, he tells me there were some indications of deception in her test. However, he was not happy with the test. He said she was having her period and she was taking medication. Didn't say what kind of medication. He said, I'd like to do another test in about a week. And so nothing there. And so from that point, she's released. And that's pretty much what happened that week. I talked to the young man, nothing there. So by the end of the week, I'm at a dead end. Monday morning, the 11th, I arrive at work, and there is a police report called a supplemental DR. A DR is a departmental report. So there's a supplement from Officer Anderson. Officer Anderson was called to the home because they had a report of a suspicious vehicle. Paul Hinkle, a relative of the Williamsons, recently discharged from the Marine Corps. He was staying with them temporarily until he could find other accommodations. In the meantime, he was walking down to the corner, 7th Street and Marlatt, and meeting her when she got off the bus. She was afraid to walk, as well she should have been. While he was waiting, he noticed a car driving in the area slowly. Single occupant, but he can't tell anything about the occupant because it's dark. He makes a mental note of the license plate, DFL 312. So after this, he tells Anderson, and Anderson checks the motor vehicle division and registered to an Oldsmobile. His DR is not exactly tells us what happened. Either he or they had another officer on that particular beat check the car. And it comes back that that car had not been driven that evening. They woke the people up in the middle of the night, and that wasn't the car, that wasn't the license number. First thing I did when I left the office was stop Dunkin' Donuts. And from there, I go on down and meet Paul. We had a discussion about the car. He tells me that it was light green, but he also says that he thinks it was a 1953 Packard. The reason he's so sure, or thinks he's sure, is he had a friend with a 53 Packard. So I said, Paul, let's go look and see if we can find a 53 Packard. I carry a Polaroid camera back in that day. I'll take some pictures and we'll put out a bulletin. Stop and inquire. Nothing else. So we'll go over to Otis Bacon, Studebaker Packard dealership. Packard had gone out of business, and Studebaker was now handling the work for Packard. We got there, introduced ourselves, and we said, "Do you have a 53 four-door Packard?" They said, "Yes, we have one out in the backyard. You can go out and take a look at it." Paul and I go out and we look at the car. There's ropes across the front seat. It's got vertical striped upholstery. Those things kind of match. So I take the pictures, and we now feel like we might have a lead, possibly. Not much. I take Paul home and drop him off, and then I go back to the department, and I call Motor Vehicle Division. I give them what Paul had said DFL was sure about, the letters. It wasn't so sure about the numbers. So I asked Motor Vehicle Division, would you check DFLs and see if you have anything on a Packard? Well, you know, back in '63, that was a hand count. It was around 1,000 possibilities with that prefix. So at the end of that, more at the end of that day, they call me back, and they say, we have a Packard registered to Twyla Hoffman, 210 North LeBaron Street, Mesa. And so now we have something we can check out. Unfortunately, it's toward the end of the day, and it's a long ways over to Mesa, and so we decide to go the next morning. The next morning, my sergeant, Seymour Nealis, says, I want you to take another officer with you. These are precautionary things. Bill Young. Bill Young has about 10 years or more on the department, so he's more of a senior detective. But it's my case. It was given to me, and I was the one doing the work up to this point. Bill and I go to Mesa, and we check the address. Vacant. And so we asked some neighbors. We checked around. Neighbors said, oh, yes, there was a nice couple there. His name is Ernie Miranda and his wife, Twyla, and they have 3 children, and they just moved the 10th, a couple days before, in a United Produce truck. Do you know where they went? No, they're supposed to have gone down to Phoenix somewhere. And so from there, Bill and I go to the Mesa Police Department. And we said, in their record bureau, do you have anything on a local resident by the name of Ernie Miranda, mid-20s? And they said, let's check. And they come back and says, yes, we do. We have a guy by the name of Ernie Miranda, and he has an extensive record, starting as a juvenile. And as a juvenile, he was involved in a number of different things: peeping Tom, truancy, stolen vehicle, burglary. He saw a woman in her bedroom, in bed, nude, while he was peeping in the window. He tried the door and it was unlocked, so he went in and attempted to molest her. The husband came home, or maybe he was in the other room, but whatever. So he was apprehended. He was sent to Fort Grant. Now, if you know anything about Fort Grant, it's out there close to Mount Graham, out by Safford on the east side of the state. And it's where they send the young people, the juveniles who have serious crime problems, because we have a local one here called Jamerson back in that day. And so for truancy or runaways or incorrigibles, they would go there. If it was a serious crime, after a hearing and all this, they would go out to Fort Grant. Little side information about Fort Grant. They had another very famous person that had something to do with Fort Grant. It was actually Bonita, which is a little town right close to the fort. And his name was William Bonte. Anybody remember William Bonte? Billy the Kid, killed his first person, right there. So they have a little history with famous people. Anyway, I understand that he had actually been to Fort Graham twice. So the next thing is on his record. He shows up. Well, that's not on his record because that's an FBI report. He's a juvenile. They're telling me about this, but they do have an FBI report. It shows that he was arrested in Los Angeles. I think he was 17 at that time, for robbery. He was also was in the Army, and back in that day, sometimes young people, they give you a choice whether you want to go to jail or go in the Army. That was not uncommon. Anyway, he went to the Army, but life in the Army didn't suit him any better than civilian life. He was in trouble. He went AWOL. He spent some time in the stockade. All of these things are judicial proceedings, which I will make a point of later on. And from there, after the Army and his discharge, he shows up in Texas on a vagrancy charge, one more of these things where he's in the system. And the next one, the most serious, was stopped driving a stolen vehicle in Tennessee, which he had crossed the state line, the Dyer Act. And so he spent a year in federal prison. So he's a convict. He's been around. He knows the ropes. There's nothing else shows up at that time. He must have got out of jail and met Twyla somewhere along the way. She was married. She had a couple of kids. And so they hooked up, came back to Phoenix because he met her in California. And they were living here. Anyway, I'm getting a little ahead of my story. After we found this thing out in Mesa, we returned to United Produce and we found out that he worked there on the night shift, dock worker, and they praised him as being a very good worker. He was also worked alone, no supervision, worked all night. So he had a lot of opportunities to get around if he got his work done. So after that, they didn't know where he lived. They didn't know where he had moved to. They did know that he borrowed the truck. It was okay. And he moved to Phoenix the next morning. Now this starts on the 11th, and then we talked to Paul, and then we went out to Mesa. But now it's the 13th. Because in Mesa, before we went to Mesa, we had to wait the next day. And we went to the post office, the one right at Central, or between Central and First and Fillmore. Went in and said, do you have a change of address for a Twyla Hoffman or a Ernie Miranda? And they said, yes, we do. It just came in. It seems that he's moved to 2525 West Mariposa. So Bill and I now proceed over to Mariposa. This is about 9:30 in the morning. I go up and knock on the door. Well, by the way, as we walked up, I looked in the car. It's got ropes behind the front seat. It's got vertical striped upholstery. And a woman comes to the door. She's carrying an infant. We identify herself and we say, is there an Ernie Miranda live here? She says, yes, he's asleep. May we speak to him? She says, just a moment. We stood outside. A few moments later, Ernie shows up, no shirt, no shoes, pair of khakis, hair mussed up, obviously been asleep. So he comes to the door, says, once again, we identify ourselves, and he says, what's this about? We said, Ernie, we'd like to speak to you about a police matter. He said, well, come on into the house. So we come in, we stand in the living room. I'm getting some details here because part of these details, if you're a policeman, they're important. So once again, he wants to know what we want to talk about. We said, we'd rather not talk to you here in front of your family. Would you mind coming to the police department with us? We'll check it out. If you're not involved, we'll bring you home, no big deal. He said, okay, let me get dressed. So he goes into the bedroom to get dressed. We do not follow him into the bedroom. If he'd have been under arrest, we would not have left him out of our sight. He could have come out of that bedroom with a gun and killed us both. He doesn't know why we're there. We didn't tell him why we were there. A police matter. Comes out, and a few moments later, he's put on some shoes and a t-shirt, combed his hair. We get in the car, and as we're proceeding down to the department, he wants to know what's going on. And I tell him, let's wait until we get to the department. We'll cover that when we get there. My partner, Bill Young, says, we're going to be talking to you, but you do not have to talk to us if you don't want to. You don't have to answer our questions. And if you're not involved, we'll bring you home. It's very clear that he was not under arrest. I make that point because later on in the trial, I was asked, was he in our custody? And I answered yes. After having thought about it, very quickly, I thought, well, I know what arrest means. I also know what custody means, but they don't necessarily mean the same thing. Because you could have child custody or custody of property or any number of things that fit in the area of custody. So my thinking was, when I answered yes, well, he was with us, and so therefore, it was okay. I answered yes. Later on, they made a big thing about he was arrested at his home. He was not arrested in his home. We got to the department. We went into what they call interview room now, and was called interrogation room 2 at that time. And so we sat down and we asked him some simple questions. Where were you on the night, in the early morning hours of March 3rd, just a little week before? He said, I was working. And they have my time records. You can check it. Okay. We will. Were you driving your car that evening and to work? Yes, he was. Did you happen to pick up a young lady on the street and you and her went out into the desert and had sex relations? We've not accused him of a crime. He says, no, I was working. Okay. And so we went through that, and it was not a long interview. He denied it. We asked him about his record. We brought up the fact that he had been in trouble for molesting a woman. We brought up the fact he's an ex-convict. And we brought up the fact, without telling him exactly how, that perhaps he would feel better if he told us about this incident, confession. That's based on the fact that he had asked somebody to pray for him, the victim. Our thinking was he probably has some religious training, and he's concerned about his moral activity, so he's asking for prayers. Now, I don't tell him that what she told us. I just said, you would feel better, if you believe in God or whatever. And so he denies everything. So we're getting nowhere. So the last question was, Ernie, would you mind standing in a lineup? He says, yes, I'd stand in a lineup. Now from that point, we now have to get 3 other guys. We go up to the jail. Bill Young goes to the jail. And he gets the 3 guys. I get on the telephone, and I call Patricia Weir. By this time now, I didn't know about these things before, but the sergeant said we have a couple more cases that he may be involved in. So he tells me, one of them is Barbara Sue McDaniels. And then Barbara had been picked up in the downtown area, not far from the theater. Guy forced his way into the car with a knife, was going to rape her. They drove to an alley. He drove her car to an alley. And there she managed to talk herself out of being raped. But she nevertheless had to turn over her money. He robbed her. We had another case, Sylvia McLeod, happened on February 22nd. Both of these cases were about 8:45, 9 o'clock in the evening, both of them. During a time that Ernie could have been or should have been working. Sylvia's case, he had forced his way into her car with a knife, and a car come along, and the lights were on the car and shining in, and she started screaming at the top of her lungs. And Ernie left. Of course, she didn't know it was Ernie at the time. And she made a mental note. Besides his physical description, and he had no accent, which also was stated as a part of Barbara's case, had a tattoo on his arm or on his hand. EM. Well, I wasn't able to get her. She was not available at that time, didn't answer the phone, so we went with two people, Barbara Sue and Patricia Ware. So we got three other males. Ernie picked his own number. He picked number 1. And they stood in the lineup. And the first person we brought up to the window. We have a one-way glass. You can see in, but they can't see out. And she said, it looks like the number 1 guy. Looks like, but she believes it's the number 1 guy. But she won't say positively, because the next question the cop asked, are you sure? Are you positive? Well, no, but it looks like him. Okay, well, we're going to have you sit over here. These two people never got together, Barbara. We kept them separated. We have somebody else to look at this lineup. So the next person comes in is Barbara. She looks in there. She immediately picks out number 1, just like Patricia did. Same thing. She looks like the number 1 guy, but he had a mustache back in November, but it looks like him. Are you sure? Well, no, but it looks like him. Now, Patricia said maybe she'd identify him if she heard him speak. So we said, okay, we're going to put you over here, and right now I want to go back in and talk to Ernie before we go any further. We're going to have him talk to these people and answer questions. So we take the prisoners out, leave Ernie there. Bill and I go back in. I sit down, and I don't say anything. What you're hearing now is facts happened. What you heard a while ago was not exactly how it happened. So I said nothing. And I was kind of remorseful looking, wondering, kind of shaking my head. We had established rapport. The interrogation, if you will, only lasted a half an hour. And he didn't confess to anything. So he asked me, how did I do? And as you heard, I said, you didn't do so well or so good. He said to me, I didn't say to him, he said to me, they identified me then. And I said, yes, they did. That's not a lie. Because they did identify him, they just weren't positive. That is not a lie. So he says, well, I better tell you then. I'll tell you about it. I said, that's a good idea, Ernie. So Ernie sits down. First off, he's already sitting, but he tells us what happened. And when he's through telling us what happened, I said, Ernie, would you put that in writing? We have a witness suspect statement form, departmental form. And we produced it. And he says, yes. And he writes, first off, at the heading of there, after we fill out the heading, it says, I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercions, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I may be used against me. It's up there if you see it, and if you want a better copy, I brought extras. Now, he writes a confession as he told it. We did not tell him what to write. And I'll make a point of that a little later on. You'll notice he has excellent handwriting, very good, excellent spelling. He describes the sex act and the anatomy of the male and the female in this act accurately. We did not tell him what to write. He put it in there the way he saw it, the way he told us. And he rationalized somewhat. That's okay. We allow that. We expect it. In fact, one of the things he said, he took her clothes off with cooperation. Well, that's an interesting thing. He's already put a knife to the skin and tied her up and kidnapped her, and now she's cooperating? Well, anyway, that's his statement. That's okay. That's all right. We don't mind rationalizing. Everybody rationalizes a little bit to some degree, and when you're the worst kind, you don't want to look back in that mirror in the morning when you shave and see a monster looking back at you. So he writes a very nice little short. We only have one page. He used the whole page. We would have given him more if he had wanted it. But he was satisfied. He told us what he had and what he had said. And so that is how it happened. From that point, we now ask him about Barbara's case. Now, Barbara's case was not my case. It was a robbery case. At least it started off as an attempted rape, it became a robbery. And then now we ask him about that. And we identify where it happened, when it happened, and he says, yes, I did that. We didn't ask him to write a confession on that. Frankly, I'm a detective, and I'm worried about my case. I'm not going to worry about somebody else's. If they want a confession, let them get it. Then the next one is, I ask him about Sylvia McLeod. Sylvia McLeod. And it happened in February that year. And she identified him with a tattoo. E.M. Ernie, you got a tattoo on your hand, E.M. Did you do that? He says, yes. He also confessed to that. Now, she wasn't there, but he made the confession that, yes, he did. Incidentally, there were a number of cases down in that same area with a guy that met that description and had been robbing women at knife point, getting in their cars and so forth. I didn't know about, excuse me, keep doing that. I didn't know about any of those things when I started my investigation on Patricia Weir. So the sergeant gave it to me. The confession in that case was a verbal confession. We said, you're under arrest, Ernie. At that point, we've now placed him under arrest. We did not have probable cause to arrest him when we took him down there. A car with a different license plate seen a week later, becomes suspicious, and we had other things adding up to this now with his past record, but this was the first word that was made about arresting him. The Supreme Court and the petitioner's brief get things a little balled up, but that's okay. That's what they do. Cops deal in facts, and we try to make sure they're accurate. And when we go to court, we tell our story and let the chips fall where they may. As a police officer, digressing a little bit. We work by the rules, by the laws that the legislature makes and interpreted by the courts. We don't always agree with those rules. I don't agree with some of the things that the Supreme Court's inflicted upon the police at this time. But that's not important, because it doesn't matter whether we agree or we don't, we just follow the rules. And that's what we do. Now, Ernie's confessed, now he goes to court. And during the court, I said I made a mistake. I said he was in custody, and they made a point of that, and that's where they said I arrested him. And I admit my mistakes. If I make them, I'm going to make mistakes. We all do at times. So I made a mistake by saying, yes, he was in custody. So that became a point of arrest. Wasn't quite the way it happened. So now, we now have finished our portion. We go to court twice, by the way. Barbara's case went first, the robbery, and we testified he was convicted 20 to 25 years. He has a past record, remember. So he's now going 20 to 25 years. A week later, he gets, I think it was a week, it was same judge, same defense attorney, Alvin Moore. And so the next week we go to Patricia's case. Same thing, we tell our story, we have the evidence. The prosecutor, Turoff, did call the medical profession, the doctors. He probably didn't feel it was necessary. And I mention only that because there was a point in this case when they said there was no medical testimony given to whether she was actually raped. Well, whoever is writing this stuff and arguing it, I cannot believe that they haven't read the police reports as public records. And if they read the police reports before they make their arguments or the appeals, would they not know that the doctors had part of that report from the doctors collecting mobile sperm, as they describe it? So after he was convicted, he went to trial again, and it was Patricia's case. And of course, we introduced the confession and what he said and how we come to believe that he was involved and the steps we went through to get to him. And so he was once again convicted and given 25 to 30 years a second time on the Patricia case. Separate trials, separate sentences. Somewhere along the line, and maybe Paul knows, they were combined and they just give him the one concurrent. So anyway, now Ernie goes to prison. And a couple of years later, we're going to go back to trial. The court has overturned the conviction, reversed it, sent it back to Maricopa County for retrial. Here's what happened in this case. Bob Corbin and Maurice Berger, his chief deputy, Corbin is the county attorney, later the attorney general for the state. They call me, Bill Young, as they always do, to find out what he can testify to. I get there, and Corbin and Maurice say, we just don't think we can get this case to the jury. The confession's out. The lineup's out because Now they're saying, well, they weren't sure. And by the way, going back to that, we did bring them in, and the two of them, and Barbara came in second, but when she came in, face to face, short distance apart, she pointed her finger at him and says, "That's the man." We never told her anything else about it. So she made a positive identification. In Patricia's case, like I'm backing up a little, but Patricia's case, we come in and we ask him questions because she wanted to hear him speak. And we ask him some routine questions like your name, where do you live, where do you work, or whatever. And he begins to talk to her directly, and that wasn't what we wanted to happen. But he admits to her that that they were together. So we didn't tell him or anything else that this was the guy and ask him that particular question. Is this the woman that raped you? We didn't ask him that. He started answering regular questions to hear him speak, and he started talking to her directly, so she went out of the room. We took her out of the room, and she's, "That's the guy. I know it." As soon as I heard him speak, well, it's a little late because he's already confessed to her. So that one's not very good. Perhaps the police procedures weren't the best in that particular case. So now he goes to prison, and I've already said that. And we go back to trial, Maricopa County, and I'm in the prosecutor's office. And Corbin says, "I don't think we got much of a case here. No confession, no lineup." And I'm looking at the witness list. And I noticed that on the witness list is Twyla Hoffman. And I asked Corbin, "Does anybody talk to Twyla?" He says, "No, we can't find her." Well, she'd only lived in that house 3 days. It was a rental house. Hardly, 3 years later, is she still going to be there? So I said, I don't know what she could tell us. She might not be the best witness. She may be hostile. Because as we went through the original trial, she was glaring at me all the time. I had arrested her man. And so I said, "But we need to talk to her, we need to know." They agreed. I said, here's how we might find her. The senior Mirandas are good citizens, lived in Mesa for a long time. Ernie was born in Mesa. He was not a Mexican. He was an American. Anybody born in this country is an American. And if you claim somebody's a Mexican and they're from Puerto Rico, they will be offended, or Venezuela, or anywhere south of Mexico. But nevertheless, that's a side issue. So I said, send your investigators, county attorney investigators, over to Mesa and see if they know where their granddaughter and Twyla may be. They did. The next day, Corbin calls me back, and he says, "We found her. And she's working at the Mesa Community or Mesa General, I don't recall the last part of it, Mesa Hospital." And they called her while I was there and said, "We have a subpoena. We'd like to talk to you, see what you can tell us." So he said, "Where can we talk to you?" She said, "Well, right here at the hospital." Moise, Corbin, and myself drove over to Mesa. On the way, Corbin says to me, "I want you to handle the interview." I don't know why. But instead of them handling it, they want me to handle it. I said, "Okay." So we meet with her in the lobby. And there, I said, "Do you remember me?" "Yes, I remember you from the trial, from the previous experience." "And would you, what can you tell us about Ernie? Did he ever tell you about this?" The answer was yes, he did. "When was that?" It was when he was in the or in the jail after the original arrest, county jail, and I used to go visit him almost every day. And he told me that he did this. In fact, here's another interesting thing. Maybe this is part of the reason why she told us. Ernie told me, I want you to take our baby, her name is Cleopatra, by the way, baby in arms, and go see Patricia. And tell Patricia, if she won't testify against me, when I get out of jail, I'll marry her. Well, you know, Twyla didn't think much of that idea. And by the way, she didn't testify to that particular statement. That was not asked of her. That's what she told the three of us. But she said she would. She agreed. So next we go to trial. And I'm given permission to sit with the prosecutor at the prosecutor's table through the trial as the assistant to the prosecutor. So Maurice and Corbin and myself sitting right there. I testify, and whatever other testimony was given, I don't recall, besides I testified to what we did. And we used it, he had to use a different name, Jose Gomez. That was the name they tried him under, Jose Gomez. So then they called the next witness, prosecution, Twyla Hoffman. Flynn jumps up. He says, I object. Privileged communications. Now, I don't know if Corbin knew this or didn't know it or if Flynn knew it or what, but I just said to Corbin, they're not married, nor have they ever been married. Corbin gets up and says, they're not married, Your Honor, nor have they ever been married. There is no privileged communication. He sits down. Flynn jumps up again, if he's not already standing, I don't recall, and he says, common law married. They're common law married. And I said to Corbin, once again, there is no common law in Arizona. Now, he's an attorney. I'm pretty sure he knows that. I said, in fact, there is a case, and I quoted the case, Superior Court case. The reason I knew that had nothing to do with this trial. I was now a training sergeant at the academy, the training sergeant. And I taught a lot of different classes. And I talked about the difference between common law and legislative law and so forth. And I had this old case that I could refer to in my class. So once again, Flynn is overruled. Now here's the irony to this. He's convicted. And why is he convicted? Because he confessed. Not to the police, and that was some of the questions. I didn't send her up there, didn't even know it. This was a couple years before. He confessed to her that he did this. She testified to that. As Paul said, Flynn was a really good attorney in the courtroom. He raked her over the coals. He tried to break her every way possible, as attorneys do. She stood up very well. Very brave lady, in my opinion. He didn't shake her, and she testified. He was convicted once again. So he goes back to prison. He spends 11 years from the time, I guess, from the time we arrested him until he got out, but he had a short time when he got out on parole and got in trouble, had a gun under the seat, and when he was stopped and didn't have a license, et cetera, and he went to jail, and that case, I think, was eventually thrown out, but didn't matter. He went back to prison. When he got out of prison, he became a local character. And so He would see officers on the street and he would say, "I'm Ernesto Miranda of the Miranda decision. Do you have any of those little cards, the rights cards?" They said, "Yeah." He says, "You mind give me some?" "Sure." Well, we're pretty generous people, and it doesn't cost us anything, by the way, to give those cards out. In fact, I brought a few here that I will pass out to anybody that's interested. They're not worth anything. Miranda's card may be, but I've signed them. And so then he would sell them. He'd get $1, $2, whatever he could get. So he was a local character. And by the way, he always went by Ernie, except when he became famous, and then he became Ernesto. So now, he's out on the street 9 months to the day after he was, to the 9 months to the day from the time he was sentenced, I guess it was. He got out, excuse me. He's involved in a card game with 2 other Hispanic males, the La Amapola Bar, 233, South 2nd Street. And during the card game, they have an argument over money, and they get in a fist fight. And Ernie kicks their butt, both of them. And so one of them is named Fernando Rodriguez. So Fernando, Ernie goes into the bathroom to wash some blood off. I don't think it was Ernie's, I think it was Fernando's. While Fernando's getting ready to go, he goes over to a drunk that's laying on the floor, passed out. Now, he happened to know this guy had a knife. So he gets the guy's knife, and he hands it to the other Hispanic guy and says, "Here, finish it with this." This we get from the witness, Marianne Estrella, works in the bar. So when Ernie comes out of the bathroom, Marianne says, "Ernie, that guy's got a knife." Well, Ernie's a pretty macho kind of guy. So he goes over and going to take the knife away. And in the process, he gets stabbed twice, once in the stomach and once through the heart. And he dies on that dirty floor in that bar, the La Amapola Bar. And so that's the story. Now, one other thing I brought up here, because I don't want anybody to go away thinking I've embellished my role in this particular incident or any other. I only came across this here recently when I was going through some old files that I had. And this is the letter from the Maricopa County Attorney's Office. I want to read it to you.
I was going to offer to show it on the board if you want.
This?
Yeah.
I don't think it'd read it.
Okay.
This letter is written to express my appreciation for the fine job performed by one of your officers on a recent retrial of the case of State versus Ernesto Miranda. As you well know, this case was brought to the United States Supreme Court and returned to us for retrial. Mr. Miranda was defended by John Flynn. The officer whom I refer to is Sergeant Harold Cooley. Cooley was present when Miranda's common-law wife, Twyla Hoffman, was interviewed, and the interview was, in fact, handled exclusively by him. It was due to his ability and competence that we were able to obtain Mrs. Hoffman's willingness to appear as a witness and to testify that Miranda confessed to her. Without this confession, we would not have been able to get to the jury. Sergeant Cooley not only assisted us in the above regard, but also helped in many other areas requiring additional investigation. That's when I told him how to get the hold of Twyla. He also appeared and testified as a witness at the hearing on this voluntariness of this Miranda's confession to Mrs. Hoffman, and he did an excellent job under cross-examination by John Flynn. Yay! In closing, I wish to state that it was a pleasure work with Officer Cooley and his exceptional performance in an important case reflected to your department. Like I said, I come across that recently. I thought, hey, that's not bad.
The next person that I'd like to introduce to you is a man by the name of Robert McWhirter. I got to know Robert when we were both, it was last year or a year ago, 2 years ago, both of us audited a class at ASU Law School by my original contracts professor. Yes, he's still teaching, or at least he was then. We audited a class on the law, in the evolution of the law in medieval England. And we used to ride back and forth on the light rail from downtown Phoenix to class. And I got a chance to meet with him. And at that time, I think he had just left the Federal Public Defender's Office. He has a long history as a public defender, but I think he had just taken up leading the ASU College of Law student law program. Is that right? He's written at least one book that I found very interesting, readable, and informative on the Bill of Rights. I've heard him speak on the Magna Carta last year, and he's now going to talk to us about the Miranda decision and its evolution, and I think you will find it very interesting. Please join me in welcoming Robert McWhirter.
I was able to get here early and put my book on the pictures of the screen while I did, which I thought was clever, Mark. I know. Yeah. Can you turn on the book? On? There it is. Also, these are my children. And, if you'd like to help support these beautiful children, I always said if I can buy enough books, to keep them from alignment, crime, and dissipation, I can afford to send them to trade school. So, yeah. Come to us on a faded parchment. That's a term actually in Miranda. Miranda has, at least the precursors of Miranda, have a long history in common law. The right to suppress confessions goes way, way back in common law. Read them as rights. Every cop buddy story ends. Read them as rights. Dragnet. Now, I know several people in this audience do not know about Dragnet. I'm sorry about that. Adam 12. Okay, talk to your parents about Adam 12. Every episode ended with read them as rights. Okay? You get the ritual spoofed. You may have seen Dragnet with Dan Aykroyd and Tom Hanks. It is the greatest parody of Jack Webb I've ever seen. You get the iconoclasts. You get the iconoclasts of the ritual. So you get Dirty Harry or Law and Order take the same ritual and kind of play with it. And Dirty Harry kind of like grabs the ear, slams his face on the desk, and says, "Okay, it's right now." The Fifth Amendment, though, is what you call in legislative draft a Christmas tree. There's the grand jury stuff, due process, takings clause, double jeopardy. Although there actually was a movie called Double Jeopardy, most of the time Hollywood producers don't see the dramatic value of the takings clause of the Fifth Amendment. Silence is what creates the drama. And that's why this becomes interesting. It's how do you get the bad guy to be able to confess to his crime or prove guilty? It's the silence that makes it work. But in reality, there is actual, quote, no right to silence, end quote, in the Constitution anyways. What the Fifth Amendment says is, nor shall a person be compelled in a criminal case to be a witness against himself. So the question is, how do we get from that to Miranda's articulation that you have the right to remain silent? Enter Miranda. You have the right to remain silent. It's not limited to criminal cases, nor is it limited to defendants. How many times, have you seen a congressional hearing where he says, congressman or senator, I respectfully assert my right to remain silent. But that's not a criminal proceeding. Earl Warren, of course, led the Warren Commission, which was all part of the movie JFK. All right. Quote, the term privilege against self-incrimination is not an entirely accurate description of a person's constitutional protection against being compelled in any criminal case to be a witness against himself. United States versus Hubbard. Thomas and Scalia wrote concurrence, kind of talking about, hey, where do you get when there's not compelled stuff to actually go? Yeah. Can people not hear me? Not going to the control room. Right? We don't want to leave the control room out. The Hubble case dealt with Webster Hubble and Kenneth Starr. One of the more interesting quotes. Basically, Kenneth Starr had given Webster Hubble immunity, and Webster Hubble didn't say what Kenneth Starr wanted him to say, which tells you that a prosecutor should not give immunity until after he knows what the witness says. The independent counsel can indict my dog, they can indict my cat, but I'm not going to lie about the president. That's his public statement. And the Supreme Court said, hey, Webster, you are right. You have immunity, a Fifth Amendment protection. All right. Kenneth Starr lost on that one. By the way, the term witness comes from Old English. It is knowledge, to know. A witten is a knowledgeable person. Judges used to be called wit hands. There's a judge here, my friend Chris Whitten. Sometime way back in his generations, there was an Anglo-Saxon judge who was his ancestor. Either that or they just made the name up. Okay. It's where you get the word wit, witty, witless, wit snapper, witticism, wittingly, thus unwittingly, wit tooth, which is another word for wisdom tooth. If you take the German, it would be Wittooth, wisdom, so those words are related. Witmonger and wit wanton, who is somebody who uses wit wantonly. There's the movie Witness, and of course, Witness for the prosecution. And I don't care how old or young you are, you have to watch the original version of Witness to the prosecution. All right. By the way, this is all part of a much longer talk, which is entitled From Testicles to Dragnet, How the Fifth Amendment Protects All of Us. So how people who talked a lot gave us the right to remain silent. What's this bit about testicles? That is the god Mithra. Testicles, of course, known medically as testis, singular testis. They are the male genital glands in animals, in case anybody was wondering what I was talking about. Oaths were extremely powerful in the ancient world. Swearing on the Bible is actually kind of a new phenomenon in Western culture, only the last, some 2,000 years. Rule 603 requires an oath or affirmation of every witness. Now, that, of course, is the god Mithras, the god of friendships, contracts, oaths. Does anybody, is it just me or does it look a little phallic? If you think it looks phallic, you're right. What did people swear on before the Christian era? Before the Bible? They swore on their genitalia. The book of Genesis. Abram said, put your hand under my thigh, and I will make you swear by the Lord, the God of heaven and the God of earth, that you will not procure a wife for my son from the Canaanites. Israel called his son Joseph and said to him, if you really wish to please me, put your hand under my thigh as a sign of your constant loyalty to me. Do not let me be buried in Egypt. So people would swear on these things. The word testicles comes from Latin testiculi, or testis, which literally means little witness, if you go to a Latin dictionary. So, the test words, protest, Protestant, testify, attest, all have that origin. Anybody speak Spanish here? The word for witness is testigo. The word for testicle is testiculo. They're almost the same word, because it's closer to the Latin. All right. To detest is to hate somebody from the bottom of your testicles. Now, we, of course, use the oath or affirmation. I am not sure that it might not be a good idea to go back to the old genital swearing in order to assure lack of perjury in court. Okay, homie, I'll take a bullet for you, but not for that. Okay. Tony Montoya, Scarface. What do we got here? All I got is my word and my balls, and I don't break them for nobody. See, this has power. Lyndon Johnson, I never trust a man until I have his pecker in my pocket. Now, if you think I made that up, in my book, did I mention that I have a book? I have citations to every source for this. All right. So where's this? We're back on ancient times. The Talmud. No man could render himself an evil person under ancient Israeli law. You had to have the two-witness rule. At the mouth of two witnesses or three witnesses shall a matter be established. That's Deuteronomy, Numbers, and then again in Deuteronomy. So the basic procedure was two witnesses, and confessions weren't accepted. Two competent witnesses, a person could not testify against his close kin. A man was a relative to himself. Therefore, there was no confession. It was a capital sin to commit suicide. So if you confessed, it was like hurting yourself, and therefore it was procedurally barred. So let's just jump to Christianity in the Middle Ages. Although this is a condensed talk and I jump even more. See, I am allowed to just jump millennia. Boom. It's no problem. Confession was good for the soul. Before the 4th century, there was always public confession. After the 4th century, the church gained all the temporal power because the Roman Empire collapsed, which meant that, as we well know in criminal defense, confession may be very good for your soul, but it's really, really bad for your body. So, confessions are bad for the body. That's where you get private confessions. Okay, St. Augustine starts talking against the public confession because people were protecting their bodies and risking their souls. So there you get the confession. We, of course, have decided to return to public confession. In fact, probably this room would be more full, except people are out, watching Montel or Dr. Phil right now and couldn't attend the presentation. Okay. Nemo tenetur podere sepsum. No one is bound to reveal his own shame. Nemo punitur sine accusatore. No one is condemned without an accuser. This became the standard of canon law. And it's that canon law standard that moved into the common law. Now, what's the source? In canon law, biblical stories count as precedent. So you've got the accuser, remember let the one of you without sin cast the first stone. Well, since nobody was there to accuse her, she was acquitted. Now, this is not a right to silence per se. Suspects still had to kind of confess if accused, but you didn't have to accuse yourself. Now, enter Innocent III. There's a heresy problem. Living heretics must die and repent, or repent or die. Dead heretics must be dug up from consecrated ground and burned. And this was the Fourth Lateran Council of 1215. Innocent III is a biggie, by the way. He was a great reformer. He was the one who recognized the Franciscans. This is Giotto's Dream of Innocent III that you'll find in Assisi. There was a movie, Brother, Sun, Sister, Moon, which ends with Alec Guinness recognizing St. Francis and the Franciscan order. All right. What's the problem with heresy? Heresy is a thought crime. Documentary evidence was very rare in the Middle Ages. Remember, Gutenberg doesn't produce the Bible until 1450 to 1455, so there's only 22 known copies of it today. If you don't have a written record, it's very hard to prove what somebody's thinking. See, unfortunately, everything we do today is recorded. It's going to be easy to prove what we were thinking or what we weren't thinking. But back then, it was difficult. So you needed a confession. Now, you needed to get a confession or you needed to get a snitch. One of those two. So what happens? Enter the Inquisition. Now, the regular criminal procedure of canon law and the jus commune in Europe was very much against confession, with the exception of heresy. No one expects the Spanish Inquisition. Okay, you've heard of Monty Python? Okay, good. All right. The Inquisition means no right to silence, St. Thomas Aquinas. Now it is to the glory of God that the accused confess that which is alleged against him. Therefore, it is a mortal sin to lie to cover one's guilt. But again, that's only in heresy. The inquisitor has powers. He sits as the indicter, the prosecutor, the fact finder in his official capacity, and that's where you get the ex officio oath. Okay. Koch versus United States. The privilege is necessarily to prevent any reoccurrence of the Inquisition and the Star Chamber, even if not in their stark brutality. United States versus White. The privilege is firmly embedded in our constitutional legal frameworks as a bulwark against inquisitous methods of prosecution. It's this history that leads directly to the jurisprudence that still matters to us today. The quotable, the cruel trilemma. Murphy versus Waterfront. The privilege against self-incrimination reflects our unwillingness to subject those suspected of crime to the cruel trilemma of self-accusation, perjury, or contempt. That just creates inherent problems with unfair conviction. What's the modern Inquisition? The modern Inquisition today is plea bargaining. The right to silence, if you think about it, is crucial to the system. Because what is it that the prosecutor buys? What the prosecutor buys is the defendant's statement in court, yeah, I did it. Could you give a factual basis? Yes, I went and did blah, blah, blah. Well, actually, we lawyers kind of work out that factual basis. Okay, so we defense lawyers try to get as little as possible, and the prosecutors try to get as big as much. But somewhere in there, there's an admission of guilt. Losing the right to silence would crush the system. All right. Let's bounce to Henry VIII. The guy would leave you speechless. Now, Henry VIII started as the anointed king. From God to Pope to me. That's how he starts. Magna Carta, what Magna Carta? I don't need no stinking parliament either. Okay, now what happens with Henry VIII? He had this great matter. See, what it was is he was married to this charming young woman called Catherine of Aragon. The trouble was, by the time he wanted to kind of get rid of Catherine of Aragon, she didn't look like this. She looked like this. She was like, 8 or 10 years his senior and beyond childbearing years, so he wants to get rid of her and put in Anne Boleyn. And what he needed was, pass the Viagra, right. What he needed was a divorce. Couldn't get the divorce from Rome. I could have you here for an entire afternoon about what went on with Henry VIII. But Lord Chancellor Cardinal Wolsey was supposed to get the annulment. Pope Clement VII was supposed to grant the annulment. Unfortunately, Clement VII was the prisoner of Emperor Charles V, and it just so happened that Catherine of Aragon was his aunt. Okay, so it just wasn't going to happen. All right, so basically, he decides to reshuffle the marital deck, and he ends up, at the end of it, having 6 wives. By the way, you want to know how you can remember Henry VIII's wives? Divorce, executed, died. Divorce, executed, survived. Okay. Catherine of Aragon divorced. Anne Boleyn gets executed. Jane Seymour actually produces an heir. Divorced is Port of the Land of Cleves. It was an arranged marriage, and Holbein went and kind of made that charming little picture of her, and Henry VIII thought, hey, this would be a good idea. Met her at the dock, took a long look at her and said, no way am I going to consummate this marriage. Okay, then you end up with, of course, Catherine Howard, and then Catherine Parr survives it. All right, so what's he does? He makes himself Pope. The Act of Supremacy of 1535, Supreme Head of the Church of England, Archbishop Cranmer becomes Archbishop of Canterbury, grants him the annulment, everything's hunky-dory. Why does silence become golden? The king shall enjoy and have annexed and united to the imperial crown of this realm, as well as to the title and style thereof, the act of treason, to deprive them, the king or queen, of any of them of the dignity of title or name of their royal estates is high treason. So what's going on here? Heresy now becomes treason, and vice versa. In other words, if you say that the king is no longer the head of Church of England, you have now committed heresy, not just treason. Believing in the Bishop of Rome's legal power is heresy, believing non-Anglican Protestantism is, and it's enforced with the inquisitorial procedures. See, treason should be a common law crime, which means you have common law protections, like the 2 witness rules. But if you make it heresy, then all of a sudden you get to do all kinds of other things. Okay. So now he becomes the appointed king. He used to be the anointed, from God to Parliament to me. Parliament said I get to be Pope and marry the haughty. Magna Carta, I love Magna Carta. See, the Tudors totally changed the whole thing, which you can see is this becomes a precursor to democracy. Because now all of a sudden you don't have divine right of kings in England, you have the sense that Parliament somehow controls, and that's okay by Henry VIII, he controls Parliament. The Bishop of Rome could only make me king. Parliament said I get to be emperor. I love Parliament, and don't forget the haughty. Because this is what's going on politically with him. All right, enter Thomas More and the right to remain silent. He's the first Catholic in England that goes on record refusing to incriminate himself. Man for All Seasons, Best Picture 1968, 67. Still holds up well, good costuming. Kind of gets popped up. Okay. Thomas Cromwell makes More publicly refuse to swear the Act of Supremacy of 1534, and More refuses to take the ex officio oath. He just says he's merely the king's good subject. For that, he gets sent to the Tower of London. He's interrogated in the Tower. I nothing doing, nor nothing saying against the statute were a very hard thing to compel me to say either precisely with it against my conscience, to lose my soul, or precisely against it to the destruction of my body. So he's in a real dilemma. The old canon law is what he wants to invoke. Ne mor tenenter podere seipsum. And Thomas More's point is, hey, heresy's not the charge here. The charge is treason, and I should have these rights. Sir Thomas, had you not yourself used the ex officio oaths for heresy prosecutions? The difference, Master Cromwell, is in the law of God and the law of the realm. But it is only the difference between burning and hanging. That is the difference between heaven and hell. So More, who's the consummate lawyer, is asserting these rights. Enter the Fifth Amendment. Nor shall be compelled, the person be compelled in any criminal case to be a witness against himself. So More's articulation is a direct precursor to the language of the Fifth Amendment. Now, Thomas More has a trial. What do you do when you can't get somebody? You just get a snitch. The guy was Richard Rich, which is his real name, kind of a shadowy figure. Rich testifies that More in the Tower had denied Parliament's power to confer ecclesiastical supremacy on Henry. Parliament would not pass a law that could not pass a law that God was not God's. Now, Thomas More denies this conversation ever happened. Sir Thomas was convicted and beheaded within a week. No Miranda versus Arizona. You see, if Miranda versus Arizona would have been around, Thomas More would have said, wait, he can't testify. I didn't get my Miranda rights before he did that. I never would have spoken after I got my Miranda rights. This is how Miranda ties in and is designed to protect against this. Okay, what happens? Henry VIII died. His kid, Edward VII, takes over. During the reign of Edward, Parliament enacts the two-witness rule, which, of course, comes from ancient Jewish law and canon law. You have to have two witnesses, which, by the way, is found in the United States Constitution for treason. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. So this is going all the way back to canon law. All right, let's get to Elizabeth. She has two problems. One is she's illegitimate. The second is that she's a female. The movie Elizabeth had some little kind of factual things that were a little bit out of line, but I thought it was a really good movie showing kind of what the struggles she was having. Her answer was Sir Francis Walsingham, her spy master, who was that guy, played by Geoffrey Rush in the movie. MI5 and MI6, okay, James Bond, all trace their lineage, their origin, back to the spy ring that Sir Francis Walsingham created. So the origin of MI5 and MI6 and James Bond, John LeClaire, Tinker Tailor Soldier Spy, MI5 or 6, all goes back to Francis Walsingham. 007, of course, was Daniel Craig in Casino Royale and others. In the movie Elizabeth, he actually plays kind of an assassin Jesuit who's going to go assassinate Elizabeth. So probably Daniel Craig was such a good assassin Jesuit, they decided to make him 007 later on because he played that role. Okay, so she's got her problems against Catholics and Puritans, and it basically has to do with what is the role and purpose of the church. Now, Elizabeth's idea is the church should support the monarchy, should support the state. Both Puritans and Catholics, although they agree on practically nothing else, would agree that no, it is the role of the state to either leave the church alone or support the church. Now, she prosecutes Puritans in either the High Court or Commission for Ecclesiastical Causes or in the Star Chamber. Now, these are not common law courts that provide common law protections. Okay? Not in the common law courts or the chancellery courts. Now, in England, it's kind of hard for us to figure this out because, you know, the rules of civil procedure say that all courts, like the Superior Court, is a court of chancery, it's a court of equity and law. All right. Back in England, you had all these courts floating around. I mean, you need a lawyer just to figure out which court you were supposed to go to. All right. Symbol of arbitrary power, Watts versus Indiana. Ours is an accusatorial as opposed to an inquisitorial system. Such has been the characteristic of Anglo-American criminal justice since it freed itself from the practices borrowed by Star Chamber from the continent, whereby an accused was interrogated in secret for hours on end. There's a movie with Michael Douglas called Star Chamber. Okay, so again, this history permeates our jurisprudence and is the precursor to Miranda versus Arizona. Now, the Puritans like to go right back to the text of the Bible. Third commandment, thou shalt not take the name of thy Lord, thy God, the Lord thy God, in vain. Okay? 10 Commandments is still the 5th highest grossing movie of all time when adjusted for inflation. Sermon on the Mount, do not swear at all, for you cannot make even one hair white or black. Simply let your yes be yes and your no be no. Anything beyond this comes from the evil one. So Puritans took that to heart and said, hey, we shouldn't have to state an oath. Certainly not an oath talking about our religious beliefs, which are not part of the established church. Now, these legal arguments, these religious arguments start to become legal arguments with the Puritans. Magna Carta, chapters 28 and 29, are prohibiting oaths ex officio. According to them, writs of prohibition against ecclesiastical courts start to fly around because they're temporal matters. The arguments are a stretch. I don't know if anybody's read Magna Carta 28 and 29, but it's kind of a stretch to pull that out of there. But that's what's going on. All right. Enter John Lilburn. 100 years ago, every high school kid would have known who John Lilburn is. Does anybody know about John Lilburn? Okay. Oh, you're just putting your coat on. I thought there was one hand. Okay. He's tried in 1637 under King Charles I for libelous and seditious books. And he's given the oath ex officio, which was in the Star Chamber. It's an oath we had to take before you knew what the question was. He says, no man's conscience ought to be racked by oaths and imposed. I am unwilling to answer any impertinent questions for fear that my answer I may do myself harm. That doesn't work for John Lilburn. He gets convicted. Okay, well, what happens is the English Revolution happens. Charles the First gets his head chopped off. Cromwell comes in. Cromwell doesn't like John Lilburn any more than Charles I did. Puts him on trial in 1649 in a common law court and procedure. By the laws of England, I am not to answer questions against or concerning myself. The presiding judge responds, you shall not be compelled. In the course of 13 years, it became recognized that, yeah, that right to remain silent, not to incriminate yourself, had expanded and was accepted as the foundation of the law. It had moved from the struggle against ex officio oath in ecclesiastical courts to imposing incriminating questions in common law courts. All right. Now, the Puritans, of course, come to America. Anne Hutchinson's 1638 heresy trial. Anne Hutchinson had the problem of, again, being a woman. She was also a smarter woman than pretty much all the men around who were preaching, and people started to follow her instead of the ones who controlled Massachusetts Bay Colony. In Twilling versus New Jersey, the Supreme Court stated that Hutchinson trials showed that the right was not regarded as part of the law of the land of Magna Carta or the due process of law. Hugo Black, however, in Adamson versus California, after Hutchinson, the founders wanted to strip courts and all public officers of a power to compel people to testify against themselves. All right. Enter the Salem witch trials, of course. Now, in the Salem witch trials, the confessions were not evidence of guilt. See, that was already accepted. You were guilty before you got there. So, if you confessed, you lived. If you didn't confess, you got hanged. So, 50 people who confessed to being witches survived because they, were repentant. The 19 or so who maintained their innocence were hanged, with the exception of one, Corey Giles, who was pressed to death by stones. They kept putting more rocks on top of him until he was crushed to death because he wouldn't confess or name anybody else. So you've got Arthur Miller, the Crucible. Okay, Daniel Day-Lewis was actually Miller's son-in-law in that movie. But that has to deal with all of this. All right. Pressure for the Bill of Rights, Patrick Henry. Patrick Henry was an anti-federalist. He didn't want the Constitution. Most people don't realize that. So he says he smelt a rat when they were meeting in Philadelphia to write the Constitution. He urges the Constitution rejection because it lacks a Bill of Rights, including the Fifth Amendment. Congress might introduce the practice of France, Spain, and Germany of torturing to extort a confession of crime. So what does Madison do? He responds. 1789, it's 12 proposed amendments, 10 become the Bill of Rights by December 15, 1791, including the Fifth Amendment. And it goes beyond the old nemo tenetur pudere sepsim rule, and the right gets invoked actually in Marbury versus Madison and in the Aaron Burr trials, treason trials as well. So this right is a fundamental part of America based on the history. Okay. So now what does history teach us about the Fifth Amendment? A page of history is worth a volume of logic. It's a great one. And since Oliver Wendell Holmes always wrote clever stuff like that, he gets to have his own postage stamp, okay? By the way, people who like history love stuff like that. Oh, isn't that great? People who don't like history just kind of go, eh. So if you don't like history, let me suggest this to you. History is just gossip about dead people. In other words, I don't like history, but the gossip forever about whatever. Well, that's just history about living people. So just think of history as gossip about dead people or nearly dead people, and you got it. All right? So, as mentioned already, Dickerson, as Chief Justice Bales mentioned, Rehnquist was put on the court to get rid of Miranda. But it also shows that the evolution of society and also of an intelligent judge, whom I usually didn't agree with on anything, but he had the capacity to evolve to the point where when Dickerson comes to the court, not only is it upheld that it is a fundamental constitutional rule, but he writes the opinion on it. Now, by that time, Nixon was long gone, so I don't think he had to worry too much. Nor shall be compelled in any criminal case to be a witness against himself. It is a right. It is not a privilege. Now, we call it the privilege against self-incrimination because it came out of a common law evidentiary background. But it morphed long ago into a fundamental constitutional right. In the United States, the people, not the government, possess the absolute sovereignty. All arguments asserting prerogatives should be viewed with suspicion. So somebody has a prerogative against a constitutional right. Just view that with suspicion because the framers of the Constitution, based on the history they had and the culture they had, viewed them with suspicion. The exclusionary rule has ancient roots. You can go to the Inquisition and pre-Inquisition. It was always determined that a bad confession can be thrown out somehow. Even in the Inquisition, there could be a confession, but the confession had to be repeated in open court without coercion. So at least there was this notion that, yeah, we can't use badly obtained confessions, and that goes way back. Now, the application of the exclusionary rule in the Fourth Amendment context is very new. That was only put in by the Supreme Court in the 20th century. But in the context of statements, it's actually very old. The right is the foundation of plea bargaining, which I call a modern form of inquisition, which of course we all need to make the system run. The police today are the magistrates. See, back in the day in the common law, you would be brought before a magistrate by the constable or sometimes the sheriff. And the sheriff and the constable really didn't investigate the crime. It was the magistrates who investigated the crime, and they were there to also assure your protection because, it wasn't a full adversarial system. So the judge had to guard the defendant's rights against the prosecution. Well, the premise of Miranda is, look, the police are now taking the role of the old magistrates, which was the origin of the privilege. Therefore, the police have to have some responsibility to at least advise of the rights. The police are also the interrogators and the inquisitors today. And I don't really mean that term inquisitor. You can be very pejorative about that term, but I don't really mean it that. They're the ones who conduct the interrogations. Interrogations are not conducted by judges, except, of course, during plea agreements. So they've taken over that old role of the interrogator. So the premise of Miranda, and if you read the historical parts, the history that's discussed, that Miranda actually discussed, they draw this direct line. You have the right to remain silent. Because that's the modern articulation of not being compelled to confess your own crime. You have the right to remain silent. The right grew from the extraordinary. You've got Inquisition courts for heresy, the Tudor-Stuart prerogative courts for political heresy, Cromwell's special commission to get John Lilburn. So all of the people above were proponents of getting rid of the right. All the people below were the ones who wanted to establish the right. So what does that say for us today? Extraordinary procedures in need should never justify abrogating a constitutional right, any constitutional right. Now you could talk about fighting against communism, fighting against terrorism, the war on drugs, any kind of crime, any kind of justification, at least from the point of view of the framers of the Constitution, does not justify an abrogation of the right because they knew the history from which all of this came. Are there any questions? I finished 5 minutes early, which I think is an achievement. Well, thank you.